Honorable the President.
Senator Coppin.
Thank you, Madam President. Before the break, I would have given a number of statistics as it relates to the backlog in the criminal justice system. And I would have also mentioned that not only does this bill seek to deal with the criminal backlog, but it also seeks to deal with the issues of prisoners or detainees on remand yard. And it has to deal with not only the numbers, of which there are just 2,289 as at November 2016, but also the length of stay of persons remanded at that detention center. Madam President, I would like to give some statistics on that for the benefit of the House. And as it deals with the male remandees, of 5 persons between the ages, with average length of stay for the period of 15 to 20 years, 148 persons with an average length of stay 10 to 14 years, and a total of 515 persons with an average length of stay 5 to 9 years. So, Madam President, we see that not only is the number pretty large, but the average length of stay for a lot of those detainees is quite remarkable. And, Madam President, if we look at what this bill seeks to do, and the persons most likely affected, those persons who are on multiple charges, I believe, are those individuals who are likely to take avail themselves of plea bargaining as it contemplated in this piece of legislation. And of those detainees, Madam President, 858 of those detainees are on multiple charges. So those are the persons, I believe, on remand yard likely to benefit from this plea bargaining bill. And if we drill deep down into the statistics, Madam President, of those detained, what we find is that persons accused of murders, there's 976 matters in the criminal justice system, persons for murder, 5 for manslaughter, 1 for unlawful death. Now, Madam President, we can't disaggregate to know whether or not those individuals are the same person, but we can deduct or deduce that those individuals are likely to be able to plea or copper plea downward and to take advantage of this piece of legislation. Another similar category of offenses, persons of matters in the criminal justice system, we have attempted murder, 28, those accused of grievous bodily harm, 8, assault, 43, wounding, 42. As it deals with robbery and attempted robbery, 85 matters for robbery and 100 for armed robbery. And as it relates to trafficking in drugs, we have 113 matters in the High Court and 68 for possession of drugs. And that comes from the Judiciary Annual Report 2014 to 2015. So we know that persons who have multiple charges are most likely to take advantage, and we know that persons who are charged with similar type offenses are most likely to take advantage, logically, from copying a plea, as they like to call it. So, Madam President, Senator Sturge would have asked what was wrong with the former act that necessitates an amendment or repeal. And, Madam President, it is clear that 12 or 14, depending on who you ask, matters from 1999 to present, 14 plea bargaining agreements, simply is insufficient to deal with the criminal backlog. And a number of speakers would have pointed to in DPP Gaspards as being an opponent, I think, of this plea bargaining bill. But, Madam President, from my recollection, when he appeared before us in the Joint Select Committee for National Security, he, in fact, appeared to support it. Although he said there was an informal system currently operating, he believed And he has believed since 2014 that plea bargaining can assist with the reducing the criminal backlog. And I have an article here, Trinidad Express, June 4th, 2014, which is entitled "Plea Bargaining Legislation Can Help." And in that legislation, the DPP says he remains surprised that more defense attorneys do not avail themselves of the opportunity to enter into plea discussions under the Act. And my lady, Madam President, if I may continue, Gaspard said, "I do not see sufficiently compelling reasons why more attorneys do not attempt to enter into these discussions." He said he hopes that defense attorneys would avail themselves to the opportunity under the Act, since it might help expedite matters and clear up the backlog of cases in the Magistrates' Court and High Court. So it is not true to say that the DPP, Rodger Gaspard, is not in support of of the plea bargaining agreement or as a solution or one possible solution to clearing up the criminal backlog. And Madam President, I want to turn also in addressing frontally Senator Sturge's question as to what was wrong with the former act. What was the matter? And we have no other than the opinion of the Chief Justice in September 2013 at the opening of the 2013-2014 law term, in which he, and I, with your leave, I would like to read an excerpt from this article. He says, "Plea Bargaining Discussion and Plea Agreement Act, with proper training, the employment of existing and amended legislation will go a long way in reducing the backlog." He said, "There are three reasons why the legislation was rarely used. Uncertainty or perceived inconsistency in sentencing," and I think Senator Shuki soon raised that point, "concerns from prosecutors regarding improper influence," and a number of speakers would have also raised that point, and statutory mandatory minimum sentences for some offenses. And the Chief Justice went on to say, however, that the first two concerns have been alleviated by the judiciary's sentencing guidelines publication and a code of guidance of prosecutors, which has been adopted by the Director of Public Prosecution. So, Madam President, and since then we know that there has been a number of developments in the criminal justice system as it relates to sentencing, the publication of sentencing guidelines, for example. So, Madam President, the issue of mandatory minimum sentences was also dealt with in a number of cases. I think the case of Miguel versus the state, 2011, UK PC 2014, which deemed that the imposition of the mandatory death sentence was unconstitutional, as well as more recently the case of, I think, Barry Francis and Roger Hines and the state, which I believe Senator Heath was representing, one of the defendants in, and that was in 2010, and that dealt with the dangerous drugs legislation, which was also deemed to be unconstitutional. That is to say, the imposition of mandatory minimum sentences was deemed to be unconstitutional. So there has been a lot of development in the law since 2013, when the Chief Justice would have raised issue with why persons were not availing themselves of the plea bargaining legislation. So, Madam President, those are some of the reasons why. But if we look at practical examples from two reported cases, we would see how the judicial approach, to plea bargaining and plea discussioning in full glare. And I had the opportunity to sit with Ski Scotland on a break in court in the civil High Court. And I asked him about plea agreements. And actually, he pointed me to the case of Erica Williams, which was the first ever plea bargaining case in the history of Trinidad and Tobago. And it involved a young lady by the name of Erica Williams, who had been charged for murder, for attempting to murder her newborn by throwing him into the sea. She was 24 years old at that time. The baby was 2.5 months old. And she, following a dispute with her, I think her common law husband, she, in a fit of rage, decided to throw the baby into the sea. Luckily, a bystander was able to see the events as they were unfolding and to rescue the child. And in that case, which is 2004, the judge, the prosecution and defense were able to enter into plea discussions, and it was put before the judge that the sentence or the count be reduced to manslaughter because of the lack of intent to kill the child. And Madam President, Justice Musai in the Fifth Criminal Court would have considered the plea bargaining agreement in the same way that that this legislation contemplates and does not remove, and he would have agreed to impose a non-custodial sentence after deliberating on the factors mitigating and aggravating in this particular circumstance. And Senator Ramdeen would have asked the question, as it relates to Sean Faris, why, or he would have raised the issue of the dangers of the sentence not matching the culpability of the individual. He mentioned the case of Sean Faris. But, Madam President, when I asked Keith Scotland as to his own experience with this particular individual, he informed me, Madam President, that in fact, Erica Williams, notwithstanding the fact that a non-custodial sentence was imposed upon her by Justice Musai, has now become a respectable pillar in her community. She has now returned to her southern base where she was brought up, and the child is doing very well. So, Madam President, it is not in every single circumstance that the punishment does not match the crime. And public policy tells us that one of the goals of sentences is rehabilitation and deterrence. And we have, notwithstanding the case of Sean Faris, we have a successful case of plea bargaining being a serious catalyst for the reformation of an individual. And I think, Madam President, we need to look at the successes and not necessarily at those instances where it may not work in addressing or satisfying the aims of sentencing. And, Madam President, we must also remember that as per Clause 25 of this bill, sentencing remains the remit of the judge. So no plea bargaining agreement is binding upon the judge. And there are a number of safeguards. Newton hearings can still be, Newton hearings can still be implemented. That is to say, the judge has the discretion to look at whether or not the charge and the agreement fits the evidence before her or him, and to determine whether or not the plea bargaining agreement is, in fact, a just one and accords with the proper administration of justice. And, Madam President, that is one successful case. Another case which we see the development of the law as it relates to sentencing was the case of Jason Williams in 2014. And in that case, for the very first time, the Chief Justice was able to combine not only plea bargaining and plea discussions, but also sentencing, the ability to look to sentence, to give indication of minimum sentencing. And in that particular case, the gentleman was charged also with killing. This time he actually killed an infant, his son, and he asked to be removed from remand yard and to be given an indication as to what his likely sentence would be if he pleaded to manslaughter versus pleading or going to trial for murder. And, Madam President, after the Chief Justice, who incidentally took the opportunity to sit and to render a sentencing direction, the gentleman took the opportunity to accept a plea agreement with the state. And because he was so fed up of being on a remand yard, the conditions were horrendous, and I know a number of individuals in this honorable house would have gone to visit remand yard. And I think Senator Mahabir is not here, but he even took the opportunity to taste the soup, I am told, Madam President. And the persons came back traumatized, Madam President, as to the conditions that currently exist in remand yard. So we have a situation where by persons on remand yard would avail themselves, knowing the evidence before the court, because the disclosure is built into this legislation, and to say to the court, I am willing to accept, if the prosecution agrees, to plead guilty in exchange for knowing my fate in quick order. Because we know, Madam President, I would have recently recited that a number of individuals remained in remand yard for 15 to 20 years, 14 years, lengths of time which at face value is cruel and unusual punishment. So, Madam President, those are two cases that I wanted to bring to the attention of this Honorable House as to successful plea bargaining and to the developments in the law which addresses a number of concerns that were raised by the Chief Justice in his 2013-2014 speech. So, Madam President, this legislation is a step, I believe, in the right direction, and the statistics as they are necessitate or support the imposition or the reformation of the existing law and the implementation of a new law. And, Madam President, I would like to turn my attention to a number of concerns that were raised as it relates to improper inducement. And this bill broadens the concept of improper inducement and expands it such that improper inducement now includes laying a charge not believed to be supported by provable facts, laying a charge not usually laid in respect of an act or omission, an offer or promise for the fulfillment, which is not a function of the office of the DPP, and an attempt to persuade an accused person or suspect to plead guilty, notwithstanding the accused person or suspect continued denial of guilt. And, Madam President, those are the additions. There were other factors or categories which would qualify for improper inducement, which is present in the 1999 legislation and are also present and included in this present legislation. So Senator Sturge and a number of speakers would have raised the issue as to why it's not an offense. But, Madam President, I think that when we look at the reasons why it's not, the arguments for and against, we see that the arguments for, Madam President, for it not being an offense, I think squarely outnumber those for it not being an offense. And, Madam President, video recording, Madam President, the Attorney General in his opening would have said that a number of witnesses, I want to quote from his answer, I am pleased to say that the government has operationalized and is further operationalizing the video recording suites for all statements. We have installed them already in several places and we are rolling them out such that the ultimate goal is that no statement is recorded without video recording of a statement. So, Madam President, there's going to be eyes on those entering into plea discussions and plea agreements, so that the probability of a person being abused or coerced or improperly influenced is going to be minimized because of this added video evidence that is going to be installed in all police stations. Also, Madam President, there exists in the law books a number of offenses which can be applied to improper inducement. And for instance, if someone is being coerced, you can take that person up and it's a physical coercion. There's still the charge of assault. It's criminal. It's a criminal charge as well as a civil charge. And, Madam President, not only is that, but in Section 30 of this bill speaks to the ability of a person to withdraw, a defendant, to withdraw his plea agreement because he was improperly induced. So there are a number of safeguards in this bill, as well as there are a number of offenses currently on the books which would allow persons guilty of improper inducement to be held accountable for their actions. Another point Senator Sturge raised was the issue of a suspect. Now, that's a whole lot of legal speak, but I think also that the ability to withdraw a statement if a person is improperly induced, it will go back to the whole concept of inducement, to withdraw that particular plea or agreement, and to it also mitigates against the mischief that he's trying to prevent, that he speaks about a suspect being given the opportunity to enter into a plea agreement. And Madam President, this bill, there are a number of new provisions. The definition of relative is broadened. I think that's a laudable improvement in the bill. It affects section 15 of the bill, victim impact statements, and I know Senator Choate, senior counsel, would have spoken about her issue with victim impact statements, that it being a right is too much of a imposition or it gives too much power. I hope I don't misquote you, to, I guess, the victims to influence the sentence. I hope I'm not misquoting you, but I believe that she has a point. The senator has a good point as it relates to this, but I know the Attorney General in his winding up or at committee stage will deal with that particular point. But the law on victim impact statements has been evolving, and I think there's the case of O's case 1992, and the case of the Attorney General reference number 2, 1995, in which the court sanctioned the use of victim impact statements. And in O's case, it went so far as to say that there will be no inference as to the impact on the victim without a victim impact statement. So the law recognizes the importance of victim impact statements, whether or not it should be a right as opposed to a discretion to allow the judge to take evidence from a particular witness, I think is a matter of opinion, but it is, in my estimation, any potential mischief is also mitigated by the fact that there is a possibility with the leave of the court to cross-examine a particular victim on his victim impact statement. So maybe in committee stage, the Attorney General will deal with that particular point and deal with any lingering concerns as Senator Choate may have. As it relates to the question of whether unrepresented individuals should have the right to enter into plea agreements, Madam President, I think that giving an individual a right to be unrepresented is better than forcing a person to be represented by an attorney by an attorney. It is better to have the right and to refuse it than to impose upon an individual an attorney that he does not want. It's like having freedom of speech, Madam President. We have the freedom of speech, but nobody's going to say, you must speak today or you must speak tomorrow. The right is you can either exercise it or you can choose not to exercise it. So once a person is competent, and I think that matter in our deliberations in the Senate committee, in the judge alone, we all agreed that once a person is competent, so he's not suffering from an abnormality of mind, that individual should be able to exercise their right to an attorney or not. And I think it's applicable also in this legislation. If we agreed on that principle in the Senate committee, then technically speaking, we ought to, and logically speaking, we should agree on that principle in this legislation, Madam President. So, Madam President, this bill gives grounds for the withdrawal of plea agreements, so it maintains that safeguards. The sealing of records is another issue that has arisen, but I think that, and the redaction of persons' names, I think that accords well with, I think, other legislation that we have recently enacted as relates to children, for example, and protecting their rights. And that is ex post facto. That's not before. I think Senator Shiki raised the issue as to whether or not the prosecution should be able to change a plea agreement or redact. But I think that happens after the fact, so that the public does not is not aware of the details or the individuals who enter into that particular agreement. So, Madam President, I think all in all, this piece of legislation is a good piece of legislation. It improves the criminal justice system and the case flow. It is going to be effective. It's not that we are forcing persons to plead guilty for pleading's sake, but it is an effective way to ensure that justice is served. It deals, or it will assist with the numbers and the length of time persons spend on remand yard, which, as I said, is a cruel, in my estimation, cruel and unusual punishment to have persons suffering and languishing for so long. And, Madam President, it maintains the sentencing principles espoused by Wooding and Benjamin versus the state, 1964, 7 WR 479. And it gives the power remains, Madam President, in the hands of the judge. So the sentencing remains in the hand of the judge, and there are requisite safeguards to preventing against improper inducements and for ensuring that justice is served. And, Madam President, this bill protects the vulnerable. It protects the right to a fair trial. The right to attorney is maintained, and it does so in a very transparent manner and accords with the interests of the administration of justice. And on that basis, Madam President, this bill is a good bill, and I call on each and every senator in this honorable house to support this bill. In fact, in the other place, the opposition was so happy that the honorable leader of the opposition said, pass it on or before the 30th or the 31st of August 2017. And the Attorney General had to say, no, let's wait, let's hold off on it and ensure that we have the right systems in place to ensure that this bill is successful. So I think all parties, both opposition and the government, are in support of this bill. We await now to hear the Independence's view on this particular legislation. But I think in all, the intention is good and we should support it. And, Madam President, with those few words, I thank you.
Senator Ameen.
Thank you very much, Madam President. Madam President, I want to thank you for this opportunity to join in this debate on the Criminal Procedure Plea Discussion and Plea Agreement Bill 2017. And as we speak, Madam President, the Parliament website has an ongoing poll. And I don't know if members are aware, but at this time, 20% of those voters on the online poll are in favor of plea bargain, and an overwhelming 80% are against. Madam President, I want to begin by pointing out that the speaker before me, Senator Coppin, is often anticipating in terms of what is to come, in terms of what the opposition's view is, and I want to advise him that he should continue to engage and articulate the view of his own party and leave the views of the opposition to the opposition. Madam President, he was very misleading in his contribution when he indicated or seemed to be giving the impression that the opposition in the other place or in this place is in support of plea bargain and plea agreement. And I want to put on the record that contrary to what he was suggesting, that in the other place there was no vote, the opposition did not have the opportunity to vote on this matter. So please do not mislead the public, do not mislead the Senate to indicate a view of the opposition that suits your position. Madam President, I want to indicate that this some of the points in my contribution were made by the more eloquent Senator Wayne Sturge, and so there are some other. Those that I agree with, I will simply indicate without going into explaining again. Plea bargain, basically, for the listener and for the citizen and for the viewing public, is an arrangement between the prosecutor and the defendant, whereby the defendant gets the opportunity to plead guilty, often, to a lesser charge in the expectation of leniency. Madam President, the plea bargain is very common in the American legal system, and it accounts for roughly 90% of all their criminal cases. However, in many countries, plea bargain is considered as being very immoral or very unethical. It compromises the sense of justice, and the whole system of justice is not only about the perpetrator or the suspect or the criminal, as we tend to think of the criminal justice system, but also that sense of justice for the victims, the sense of justice for the witnesses, people who become part of this whole foray because they have to give evidence. And I want to talk about the impact this bill, if it becomes law, will have on those other players in the criminal justice system. While I hear the Attorney General's reasons and that he would have given in his opening, and members of the other side as well, with regards to the purpose and the reason why we should support, yes, Madam President, the courts are overcrowded. If you don't allow plea bargains, the courts could be overwhelmed and virtually forced to shut down. And that is what the Attorney General was saying to us, basically. He was saying that the prosecutors' caseloads are so overloaded that fewer trials would mean that the prosecutor, in this case, in the DPP, could more effectively prosecute the more serious cases. Defendants, of course, would save time and money by not having to defend themselves on trial, where they wish to take the option and bargain. There are different types of plea bargains. There is the charge bargaining, which is the most popular and well-known, where the defendant agrees to plead guilty to a lesser charge, provided that the greater charges will be dismissed, such as manslaughter for murder. There is also the sentence bargaining, where the defendant agrees to plead guilty to the stated charge in return for a lighter sentence. There is fact bargain, which is perhaps the least common form of plea bargain, where the defendant agrees to stipulate to certain facts in order to prevent other facts from being introduced into evidence. And this is often the case where one would want to protect a loved one, particularly protect a minor, and so on. And these situations have not been alluded to or suggested. A plea bargain is an arrangement, it's a deal, it's a contract. And it could be broken if either side fails to live up to its end of the bargain. And of course, the most likely remedy is to go to the court to enforce that agreement. So the DPP or the prosecutor can, in fact, ask for the arrangement to be revoked, the offer to be revoked. My question, where this is concerned, Madam President, one was mentioned by Senator Sturge, and that is to the competence of the attorney. It is important for the accused to be fully aware of what they are getting into. We have had many instances of forced confession, or where the accused may not know better in terms of what he or she is admitting to. But when it comes to entering an agreement, entering and negotiating a plea agreement, it is important for the accused to have a fair opportunity in terms of the competence of a lawyer. This bill does not in any way make provisions for the accused to be properly represented or for guarantees to be in place, for safeguards to be in place to ensure that they are not disadvantaged. Senator Sturge spoke about the disadvantage of having a legal aid lawyer, so I would not go into that, but those are points that I endorse. But Madam President, one of the strongest reasons, I believe, that the public in the poll I mentioned in my opening is so much against plea bargain has to do with the public trust in the police, the public trust in the prosecution, that is the office of the DPP, and how they look at witness protection in Trinidad and Tobago. How much do we as citizens of Trinidad and Tobago trust our police? A couple of years ago, the Commissioner of Police, the acting Commissioner of Police, had cause to defend the police service because there were some discussions concerning a report, the Youth at Risk report, from Professor Selwyn Ryan, that indicated that 30 to 40%, that the participants in the study, in the report, believed that 30 to 40% of the police service was corrupt. Many of the participants believed that policemen are invisible, and I quote, "Policemen are invisible members or associates of gangs, and they control gang and criminal activities." This is also in line with a Maury Caribbean poll that indicated that 59% of those polled had little or no confidence in the police, and that 43% used the term corrupt to describe the police. The police trust is important. The police are the ones who would take statements, who would do the investigations, who would build a case. The police could basically use the word of this informant, this snitch, to build an entire case. In that case, Madam President, it is important for us to ensure that rather than convictions resting on the word of the police and on the word of these witnesses based on plea agreements, that the support is given to the proper agencies to provide scientific evidence to construct these cases, and it should collaborate with the evidence being given. Madam President, the time has come for an increase in the staff, in the facilities, and in the technology at the National Forensic Science Center. Madam President, apart from simply running ballistics for guns, it's important to have a database so that comparisons can be readily made. And there's a whole science behind ballistics and tool mark identification, and we are nowhere close to that. We also must look at our DNA testing and DNA records. And even at this time, the Forensic Science Center is challenged to even do autopsies in a timely manner. So while the issue with regards to the police trust is important, to combat that, we must also have that support in terms of forensic science, hard evidence, and data. Madam President, the police service itself, there are a number of improvements that could be made without legislation even coming to Parliament. The members of the police service, Madam President, ought to be subjected to integrity checks. The issue of polygraph testing of police officers when they are giving evidence. The issue of explaining your wealth. The Attorney General was quoted in the newspaper as indicating that legislation is coming for people who walk around with big gold chains to explain their wealth when they don't have a job that could buy that. Well, I can tell you that there are many officers who live way beyond what their existing salaries permit, and this must be carefully scrutinized. The public must be guaranteed that police officers are beyond reproach, and that lack of public trust in our police and our police service as an institution is very legitimate. It remains a pressing matter that the Ministry of National Security, the National Security Council, and the ministers themselves must consult on before bringing to Parliament new constitutional arrangements for the management and operation of a trustworthy police service. Madam President, there must be new efforts to target the corruption within the police service. The existence of rogue elements within the Trinidad and Tobago Police Service is well documented. We have had a number of inquiries. We have had a number
Senator Ameen, the bill at hand, while there are issues about other agencies that will arise, it's not entirely about the police service. So you need to sort of put your comments in the context of the bill, okay? You spent a long time on the police service thus far.
Thank you, Madam President. My intention was, of course, to come back to how the impact this would have on plea bargain and the importance of the police and the corrupt element within the police service. Madam President, if you would permit me, the point that I was coming to is that because corruption can be seen as being so institutionalized in the police service, and the police would be the ones responsible for gathering evidence that could be used to bargain for plea bargains, the perception that the police has been given dishonest assistance and protection to the criminal elements, that they are willfully blinded, they turn a blind eye to a lot of criminal activity, that the police is sucking on the juicy fruit of extortion.
Again, there is freedom of speech and freedom of expression in this chamber. But at some point, we must hold back a little bit. A lot has been said about the police service in this debate already. And there's no need to give such, whatever. Just try and get back to the bill, please, okay? This bill is not about the police service, okay?
Madam President, I respect your ruling, but Madam President, I want to move on to another point which has to do with witness protection, and I hope that you will see the relevance of witness protection to the...
Have a seat. It's not to please me. It is to abide by the standing orders and relevance. And I just want to caution you, there have been numerous speakers before you who have touched on several of the issues that you are touching on now. I've given you the leeway, but I want you to be very careful with tedious repetition at this stage, okay?
Right. Madam President, thank you for your guidance. I move now to the issue of witness protection and the confidence that the public has in witness protection in Trinidad and Tobago. Madam President, it is no secret that trials in our judicial system are rather lengthy. There have been a number of instances where the integrity of the witness protection service has come under question. The capacity of the court to shorten those trials is an issue that we also have to treat with. Madam President, I remember sometime in the newspaper it was widely reported about a witness who was in witness protection and was selling drugs. and it came out during the trial as to his illegal activities while in witness protection. Madam President, there have been a number of witnesses, key witnesses, who were killed while in witness protection. The witness protection program must be strengthened, and at this time, even the present, many witnesses decide to leave the witness protection program because they do not feel safe. The witness protection program does not cater, is not designed for families of the witnesses so that people are already removed from their family and they suffer. They are the ones being punished in many cases. Madam President, one of the things that has a negative impact on the witness protection program is the length of trials. There is need for us to have more courts. At present, there are 6 at the Port of Spain Assizes, and there are 3 in San Fernando. And I think members on both sides would have agreed that with 700 people awaiting trial for murder, it would take quite a number of years, decades, to clear that backlog. We must, Madam President, be able to increase the capacity of the courts, and there has been a number of suggestions, and at this time, I want to reiterate on a suggestion made by the opposition previously, and that is to double the capacity of the courts in terms of having a morning shift and an evening shift. There were also discussions about having a night court so that you can deal with matters that require less security and so on in the evenings and in night. It would require doubling up on the judicial staff. Madam President, another point that I feel that the government missed the opportunity recently with in terms of improving the state's ability as a prosecutor in terms of having scientific evidence, apart from the Forensic Science Center, was with the the changes made to the Motor Vehicle and Traffic Act recently, where I almost said the Motor Vehicle Authority. But Madam President, I think it's important for us to speedily work on having one legal entity to issue license plates. In that debate, even the Attorney General at the time spoke about the fact that almost all crimes are committed with a vehicle, which I don't agree with. But the fact is that the ease at which license plates can be purchased privately without regulations allows the criminal to simply use different number plates when committing an offense. And, of course, it gives rise to people who can very easily commit those offenses if they are arrested, could decide to bargain, and then, Madam President, comes back to the other issues in terms of the credibility of the police and the fact that there is suspicion of a lot of collusion. Madam President, I must say that while I have heard the Attorney General indicating about this being one in a series of pieces of legislation to deal with crime, I do recall, Madam President, those on the other side indicating that there was a 10-point plan that the government had to deal with crime. It included, and I just want to mention some of them and how I feel that this fails to fit in with those measures. The first one was to appoint a commissioner of police. They have failed to do that. They have indicated they would do a manpower audit. They have failed to do that. They indicated that they will establish municipal police in all 14 local government bodies. They have failed to do that. They indicated that they would give power to the police complaints authority to prosecute. They have failed to do that. that they would give parliamentary oversight to matters of national security. They have not done that. To make witness tampering an offense, they have failed to do that. And that, Madam President, has an impact on the trustworthiness of any plea bargain that you enter into, the issue of protecting witnesses. They indicated that they would make, well, I don't see the relevance of that point in terms of making unlawful eviction an offense. I don't know that unlawful eviction is one of those major crime issues in our country, but that was in the 10-point plan, so I must mention it. But number 8 was to review gang legislation. They have failed to do that. They spoke about an urban renewal plan. They have failed to do that. Item 10 was to make the Caribbean Court of Justice the final court of appeal. They have failed to take any steps to do that. So, Madam President, I really question, in terms of bringing this bill to have plea bargain, to have plea discussion in the current situation. As it is, the circumstances and the institutional support to make plea discussions a trustworthy process simply does not exist. And again, I must come back to the 3 major things, Madam President, that can be improved without legislative change. And I want to implore the government to begin the process, to improve the integrity of the police service, to improve the to prevent witness tampering, and to improve the witness protection program. And of course, the speeding up matters within the court and allowing the police to have the support of scientific evidence, hard evidence, the forensic information, and so on. So, Madam President, with that being said, I really feel that the government is rushing to bring a number of these pieces of legislation that they would have brought. Issues have also come up in terms of the fact that you recently had still continuing discussions on the trial by judge alone, the impact of having plea agreements going into a trial without a jury, the credibility of the decision that will come out of that, the credibility of the sense of justice. And Madam President, that brings me to my other point, where I indicated earlier that the justice system, victims and the witnesses as well as the accused. Most people think about the sense of justice to the victims. And we must ask ourselves, where we allow plea agreements and plea discussions to take place, and an accused person negotiates to get gets a short term, comes out, or gives evidence and somebody else takes the fall and they are back out on the street. The fact is that a number of murders are often reprisal killings. A lot of times because people feel that they don't have confidence that the police will in fact find the killers. In many gang-related killings, it is an instance where it is revenge. And I fear that having plea agreement and plea discussion in the midst of the present conditions could lead to an increase in revenge killings, where people feel that they don't feel that sense of justice, or they feel that they were denied. There was one other point, Madam President, that with regards to the persons who were party to a plea discussion, when they give evidence and they have to serve a term, this is a question, when they have to serve a reduced sentence, do they serve this sentence in the regular prison? Do they go into the prison amongst all the criminals who know each other and who know them and will consider them as snitch? Is this how people end up committing suicide by hanging by a bed sheet that is 4 feet off the ground? You know, I'm asking this question because my question is that my suggestion to you is that if you put people who are party to plea agreements, who are considered snitch, who will be looked down on their fellow criminals, when they go into the general prison population, they are at risk. And I feel that we will see a further increase in the number of prison suicides. Suicide in inverted commas, because there are a number of instances where persons who committed heinous crimes, especially against children, they somehow become so remorseful, and I hope you can detect my sarcasm, but they become so remorseful that they commit suicide overnight, mysteriously, in prison. So these are issues that I am very concerned about, and where a person who is accused can in fact be innocent, or who might be making a deal to protect themselves even though they are innocent. They might end up in the same rut and end up being an innocent victim of the circumstances and of the broken institutions that we have. So we must fix those systems, Madam President, before we could go into a trustworthy system of plea agreement. With those few words, I thank you.
Senator Heath.
Madam President, I thank you for the opportunity to contribute to this bill and act to establish a system of plea discussions and plea agreements, and for matters incidental thereto. Madam President, in April of 2014, I had the privilege of attending a workshop on plea discussions and plea bargaining. That workshop was held in conjunction with personnel from the U.S. State Department, and as well as the U.S. Public Defender's Office. And the moderator was the late Dana Sitahal, Senior Counsel. May her soul rest in eternal peace. That workshop was attended by all, or if not most, of the major stakeholders in the criminal justice system. And by general unanimous consensus, we came away with the view that the present legislation with respect to plea discussions and plea agreement was not working, mainly because it did not attract its end users, its intended end users, which are accused persons as well as the state. Because if there's not a coming together of those two stakeholders, then it simply cannot happen. And so that what you found was legislation which was highly underutilized. I myself have had some plea discussions which manifested later on into plea agreements. A lot less than I would have liked. I could count it on one hand. But for whatever reason, and I will get to what I think are some of the main reasons, the intention was never realized. And it has to be, if not the main intention, certainly one of the most significant intention, is that this intended legislation has to be designed to steer accused persons away from engaging in a full-blown trial. The effect of that would be to ease up on the criminal justice system. Madam President, let me say, plea bargaining is happening on a daily basis without use of the legislation. Every day, there is correspondence going between attorneys for accused persons and the Office of the Director of Public Prosecutions seeking to have a deal whether it is to have a reduction or to plead to a lesser charge. And the most significant is, since the decision in Nimrod Miguel, for persons who are charged with capital matters to plead guilty on the basis of the murder felony rule. Now, unfortunately, this has come about because of something which is endemic in our system, and that is, as had been alluded to by Senator Ramdeen, we do not in our Constitution have a right of speedy trial. So those accused persons who enter the system saying, I didn't do it, wasn't me, by year 9 and by year 10, they are the same ones who saying, I've been here so long, I don't know when my trial day will come. I am going to take this deal. So there is an ulterior reason for them taking it. Because when they do the calculation, and it can be brought down to almost mathematical certainty, so that we know murder felony, you're likely to start at 30 years. The fact that you plead guilty gives you a third discount and brings it down to 20. The years that you have spent inside is taken into account, so that is taken away. So let's say you started 30, you minus 10, you're down to 20, and you spend 10 years, you're down to the next 10. You take into regard remission, and that person is looking at 7 years again. So he can see the light at the end of the proverbial tunnel. And so, but that is why they take it. Now, in principle, I have no difficulty with legislation which proposes plea discussions and plea agreement. And certainly, if this bill seeks to improve, and in my view it does, the current legislation, well, I have no difficulty with it. What I will sound off, though, is that there are certain things which need to change and which we must be mindful of. And if we fail to do that, then this bill may end up just as the last one, highly underutilized and really of no effect. Madam President, let me just, so as not to avoid tedious repetition, and I hope to be brief, I will just point through the certain parts of the proposed bill which I think are commendable, where I see the different salient changes from this proposed bill and the current legislation, and then to make certain observations / recommendations. Now, I note, for instance, in the first part of the bill, there are some, in the interpretation section of it, certain interpretations which seeks to give expansive meanings to words. So, for instance, the plea agreement is an expansion to discharge certain obligations for an accused person, and I will touch on that briefly. The same with plea discussion. I note that the definition for prosecutor, unlike the current legislation, does not include the police. Now, that is a difficulty I had, because it's not uncommon when an attorney gets to an accused person, the first thing he says is, the police told me to go ahead and plead guilty, and all I will do is get a fine. So that police who is the first contact with the accused, being, and I see no indivisibility between police officers who arrest an accused person, or suspect, sorry, and a police officer who may be legally trained and in the legal department. I know my colleague Senator Sturge suggested that perhaps the police officers in the legal department can be the persons making this initial plea discussion suggestion to an accused. I have a difficulty with police officers engaging in that role, no matter what department they sit in. So that I'm glad that the proposed bill does not include as a prosecutor the police officers, who, by the way, conduct the most amount of prosecutions in our criminal justice system. Now, I know, please, Madam President, that one of the salient differences now is that you can, while you are a suspect, benefit from a plea arrangement. Now, I have no difficulty with this, but this is hardly likely to succeed if we do not, commensurate with this act, have a substantial improvement in the evidence gathering. And my colleagues have touched on it with respect to the scientific data which is required. And I'll give a simple example. The suspect who doesn't think there's anything against him, if he is shown, for instance, the basic CCTV footage with him on it, all of a sudden he's starting to think differently because he is alive to the evidence. Now, before that suspect, no matter what amount of evidence the police may have against him, there is often, particularly if it involves him having to be identified by the person making the allegation, that is the last step before he can be charged. So a police can have name of the suspect, matching description. The last thing that will happen is there has to be a parade, an identification parade, and it's only after then that you can charge. And sometimes that takes a little while to get that going. So I have no difficulty if at that stage, but it must be that the evidence has to be disclosed to the suspect and his attorney at that stage. If your case has good evidence, there's no need to hold it back. So I'm seeing in this proposed bill that you can disclose a summary. I think you should disclose as much as you think to bring the bargain to the table. The suspect now, on which I think the bill is somewhat deficient, the suspect must have a benefit derived to him at this early period. If, for instance, an accused person is likely to get a third of his sentence, and that's the going rate, just for pleading guilty, or at the very least, you are not going to attract the same sentence if you take the court through the trial. So you're going to get a discount. I think there must be an incentive for a suspect who is not yet charged to take the deal. The benefit to him is he will get a reduction more than that from which he would have simply plead guilty. And the benefit to the state is they get to scratch it off the books, and the benefit to the society at large is that we have this potential case which is not going to add to already clogged system. I find the bill to be lacking in terms of how it addresses specific sentences. It doesn't speak to, for instance, and perhaps this is less a concern for the judges who have an inherent jurisdiction and perhaps have the leeway to be a little more creative, but certainly the magistrates. So for instance, Madam President, a suspended sentence, if you were to give, by way of a pre-discussion, pre-agreement, a suspended sentence, that person who knows that he has a suspended sentence hanging over his head is more likely than not for a period to engage in behavior so as not to attract or make that suspended sentence come to fruition. And I'm saying that is how we need to now start looking at it. But together with that, one of the problems that we have, Madam President, it is not uncommon for accused persons, certainly some that I represent, to have had, prior to engaging my services, multiple matters before the court, only to find out that they were dismissed. And I asked, well, how were they dismissed? Police didn't turn up. These persons are not likely to engage into any plea agreement when they know the culture of police officers is that I'm going to run my case for a little while, see if the officer come in, and when he don't turn up, I'm going to hire an attorney and get it thrown out. That's another way which we avoid a trial, but notwithstanding, that throwing out process takes years. So it's still a clog in the system. So that behavior has to be discouraged. And until such time that police officers are made to account when they come to court, when they do not come to court, and their matters are thrown out and they don't face disciplinary actions, then it's going to keep on happening. So with this has to come a change in how we go about, certainly the police officers, prosecuting their matters for which they have brought to court. Because if that doesn't happen, you're going to find the end user, meaning the accused, who knows the system, is not going to be as attracted to this at all. So that is something that I think, Madam President, that simply has to be addressed. I know the Act focuses on victim impact statements, and in principle, I have no problem with that. Victims need to be heard, but more importantly, they need to be made aware of any plea discussion or plea agreement made in matters in which they have a vested interest, and they are victims. I like the fact that as they put it, their rights are tempered by a curtailing of the type of statement that they can give, because it's common practice to give the victim impact statements even now, and inevitably you would see somewhere in it, he should get life, he should get this, he should get that. So that could form no part of the victim impact statement according to this bill. I am not sure that I agree that there should be cross-examination of the victim. It seems to me that it could put them through an ordeal which this process can very well avoid. But more than that, if there's one victim, that's all right. But what about a crime in which has multiple victims? And they're all entitled to give victim impact statements. But what you could have is the very clog that you're trying to avoid is going to happen if there's cross-examination is allowed. I think, in my respectful view, it is not necessary for the simple fact that there is a curtailing of the contents of the statement for which the judicial officer has the final say, so that there's no usurping of his function because this statement could only contain a certain type of material and has to stay away from other types of material. Now, it has been touched on, Madam President, the use of the scientific tools that we have available to us. There has been, over the years, over successive governments, a lot of legislation which, in my view, was very pro-prosecution in that it helped the state a lot. Now, and I'll give you an example. Certainly the DNA legislation, in its first incarnation, it was you could not take DNA from a suspect, had to be an accused. That has been remedied. Had to get the consent. That has been remedied. Can be taken by force. What you have, and I've experienced it myself, is an accused person who is maintaining his innocence, but with the enforcement of the act, now has to give his DNA. And when that DNA comes back, his tune is no longer of innocence. His tune is, can I take a maximum sentence indication from the judge? How much do you think I would get? Because he is now faced with the reality, if I don't plead guilty, the weight of evidence from this scientific data is likely to send me down, and I'm not going to get the discount. So that I am saying there's supposed to be a DNA bank. Is that filling up? We need to utilize that. There's the ability now for wiretap. I don't know, but do we have sufficient undercover police officers And when I say undercover, I don't mean the ones that you've seen in the station today and they're on the road tomorrow. The ones who live undercover. These are the type of things that we need to start thinking about differently. Because if we don't, the evidence that we bring forward, not only the accused is going to feel confident about it, but his lawyer as well. So that if it's your word against the accused's word, it's 50-50. And then in a DPP's department, which is bleeding human resource. So there are young prosecutors who have to face Mr. Sturge. And he's going to back himself each time. Because as they train up, they leave. So the DPP's office needs to get the human resource and also the salary to retain the human resource that they get. So this thing has to be looked at in a holistic manner. The bill, in my view, is commendable in that it does address a lot of the concerns which I had in the present legislation. But working in isolation may very well find itself meeting the same failure. There has to be a rethink and to get all the players on board. I certainly will seek to, because if it goes through its processes, I will seek to make use of it. We need to think, Senator Ramdin raised it, the categorization of murders. If you want to see people writing into the DPP's office asking for a plea discussion or plea agreement, you categorize murders and you will see what will happen. The simple point is this. Just to make an example, murder has one of the largest, murder and manslaughter, well, manslaughter first, has a large disparity in sentencing, just by the mere fact that there are different bases upon which one can get a manslaughter. But some of the most heinous manslaughter is no different from the murder under the murder felony. Yet, just the fact that it's manslaughter, you get a lower starting point. And something has to be wrong with that. So that in those circumstances, if there's a category of murder which you can bargain for which you can cite authority for, which similar facts are for, it would seem that it would work. And you would have all these persons who have been who are incarcerated for murder, seeking to use this piece of legislation in droves, particularly if a benefit of a further sentence reduction. And I'm not talking about getting away with a slap on the wrist, Madam President. I'm saying that if you, for instance, it's murder felony, and if at the stage of the preliminary inquiry which we have now, you're willing to get into this discussion, then you might look at a 15-year period, a 12-year, whatever it is. So by that time now it seems long. But what you have happening is these people serving out these sentences, virtual sentences, without even a trial. And because of that fact, they resign themselves to take the deal. So that's somewhat unfair, because what is happening in our system now makes them a victim of the system, and they have to take a deal and try to come out. I'm saying that can be arrested. We could arrest that situation, but make it a benefit which they can see. And the first person who makes that benefit, you will see how it will be Trump and follow suit. So that, as I promised to be brief and not to engage in tedious repetition, Madam President, that's the extent of my contribution. I am much obliged.
Senator Samuel.
Madam President, I am always thankful for the opportunity to speak in this House, and in this instance, on the bill and act to establish a system of plea discussions and plea agreements and for matters incidental thereto. As has been reiterated, Madam President, the bill has some 36 clauses. And while that may be so, we have reached at this point in our society, not without many different reasons and causes, and that in some instances, we may be trying to find quick fixes to a real bad situation that has continued to deteriorate for many, many, many years in our country. And that in the quest to come up with solutions, we must be very careful that we contravene the ideas and the understanding of the word justice. As we attempt to uphold the law, but not ignore the rights of individuals, and find ourselves punishing the innocent and giving way to the guilty. It is important, Madam President, that we take heed to this. One writer, John H. Langbian, says that as the death grip of adversary procedure has tightened around the common law criminal trial, trial has ceased to be workable as a routine dispositive proceeding. Our criminal justice system has become ever more dependent on processing cases of serious crime through the non-trial procedure of plea bargaining. He went on to say, being unable to adjudicate, we now engage in condemnation without adjudication.
Amen.
But because our Constitution guarantees adjudication, we threaten the criminal defendant with a markedly greater sanction if he insists on adjudication and is eventually convicted. And that says a lot, Madam President, because from a government's perspective, plea bargaining has two advantages. It is less expensive, and we hear the issues today being one of economics. It will cost less time, less money, and as a result of that, we determine that it will be more effective based upon how much less of time and money it will cost.
Less justice.
But at the end of the day, there is a possibility that there could be less justice in our land. Madam President, it is very important for us to take that into consideration. But not only that, by also cutting the jury system almost out of the picture, prosecutors and judges acquire more influence over the outcome of cases. More so prosecutors. In plea bargaining, the prosecutors are the ones that have the big guns. As a matter of fact, from a defendant's perspective, Madam President, plea bargains are geared to extort a guilty plea. Plea bargains are not there to help the accused, but they are there to possibly tell the world that there is a deficiency in the justice system. To tell the world, Madam President, that in a time where there is a lack of confidence on the systems in Trinidad and Tobago,
Amen.
a lack of confidence because in the public there is a play for power in a system that I will not name. There is a problem, Madam President, with a backlog because of deficiencies. And deficiencies I will not even enter into beginning to discuss, lest I be pulled up for discussing another system. But Madam President, not only are there deficiencies, and plea bargaining would suggest that we are probably attempting to cover up inefficiencies. The inefficiencies of the police service to effectively investigate and detect. And because there are inefficiencies, there are prosecutorial deficiencies. In other words, Madam President, things cannot happen in the normal process of court. And history proves there are more cases that are being lost. So we have found a shortcut to commit people to prison. We have found a shortcut to ensure that we put notches on the belts of prosecutors. We have found a shortcut so that at the end of the day, prosecutors can say, we have convicted so much and so much. We've had so much before us. And we could sit and say, I deserve my pay because I've done that. And if they had gone to court,
They lost.
they would have lost. Madam President, this is serious business. This is very, very serious business, Madam President. People... Madam President, not only that, but because of where we are in our country, where we are 100% certain, Madam President, that everything is never across the board and clean.
Praise God.
As a matter of fact, Madam President, I know of a person who called a particular police station to make a report on drugs being sold in his district, and within 10 minutes his house was burned down in the same community.
Police.
So when you think about things of that nature, the setup mechanism is dangerous.
Trust.
Where for things that are not true.
Trust.
Have a seat, Senator Samuel. Senator Sturge, I think you've spoken already in this debate. Well, then both Senator Sturge and Senator Ramdeen, you've both contributed to this debate already. Let Senator Samuel have his say, please. Senator Samuel, continue.
Thank you, ma'am. And I almost said I appreciate your protection.
This is the word of the Lord. Thanks be to God.
I almost said I appreciate it. But they're my colleagues. Madam President, one chief judge, Mr. William Young, a U.S. District Court judge of Massachusetts, said that the focus of our entire criminal justice system has shifted away from trials and juries and adjudication to a massive system of sentence bargaining that is heavily rigged against the accused. So, Madam President, we must not overlook the fact that plea bargaining, though it may appear to be good, may not always be good for all and sundry. And we will need to find systems to scrutinize the work of the police service as they investigate and the work of the prosecutors as they enter into plea bargain, because, Madam President, the judge or the court is not around when the plea is happening. The judge is not there to determine if arms were twisted. And there are different approaches to twisting arms. And a simple way to twist an arm, Madam President, is really to give a person the facts and say to them, well, if you plead, I will give you 4 months. But if you don't plead, you can spend 25 years.
Mr. Samuel, could you just let us do the procedural
sure.
motion, please? Minister of Trade and Industry.
Thank you. Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the conclusion of the actual debate, including the wrap-up by the Honourable AG, but except for the committee stage, which will be done on another sitting. In other words, Madam President, until the AG has completed his wrap-up, and the committee stage will be done at another sitting.
So let me try and interpret that, Senators. Honourable Senators, the question is that this Senate continue to sit until the completion of the debate of this matter, which will end by the Attorney General wrapping up. All those in favour say aye. Aye. Any against? The ayes have it. This Senate will continue to sit until the completion of the debate of this bill with the Attorney General wrapping up. Continue, Senator Samuel.
Ma'am. Hallelujah. Madam President, we are living in hard times in Trinidad and Tobago. When people go to the store, they are hoping that they can talk to the owner for a discount. When a person goes to buy something in the market, it's hopeful that they can talk to the vendor and get a discount. And the government is now in the discount mechanism. Because the government is now saying to the criminal, we will give you a sentence discount. We will discount your sentence if you plead guilty. So the discount attitude is something that's across the board in Trinidad. And not only that, Madam President, but listen to the kind of discounts that can happen in the plea bargaining system. A person is arrested and charged for drug trafficking and distribution, and if he pleads guilty, Madam President, he could be offered a chance to plead guilty to drug possession, a discount, which is usually a much less serious crime than trafficking and distribution. Or they will offer him a discount to say, well, they can drop the trafficking charge for marijuana in exchange for a guilty plea for cocaine, for the use of cocaine. Another discount, Madam President. And the idea of the discount is that it has an arm twist to it. Why? Because if he agrees, he's all right. Yeah. But if he decides to go to court, then what they want to do is give him the full brunt of the law in prosecution. So in other words, really, such pleas are not voluntary because there are arm twisters that are lined to it, Madam President. It's important for us to see that. As a matter of fact, Madam President, to tell you of how plea bargaining has sometimes it pros and it cons, and a lot of more cons than pros. There is a case of Irma Faith Stewart and Regina Kelly in Texas. And Madam President, on November 5th, 2000, Irma Faith Stewart, then 30, a single mother of 2, was arrested. Regina Kelly, a waitress who was 24 at the time, and a single mother of 4 was also arrested. The arrests were part of a big drug sweep based on the word of a confidential informant, a whistleblower, who later would be proven unreliable. Madam President, so this informant implicated 25 people in a housing residence. Eventually, Madam President, out of the 25 persons arrested, 7 of them were forced to take a plea. When the case went to court for the other 20 won their case.
The case, I remember that.
Years after, Madam President, this reliable witness was proven to be unreliable in many other cases, and it turned out that what he had been doing is fabricating evidence against people. So what happened is the 7 persons who pleaded guilty because of force, because one person, they were a single mother who would mind their children. You know, things of that nature was taking place, Madam President. And they pleaded because they wanted to get back to their children. They wanted to get back to their situations. And they pleaded. They were advised to plead and they will get home. But these people spent some years in prison. And even though they spent years in prison, they were robbed of a lot of stuff. Why? When they came out, the mother lost her job. The families were distorted. As a matter of fact, eventually child welfare took the children into a home. Why? Because they pleaded guilty to something that they did not commit. Why? Because they were advised that if they plead, they will get a lesser charge. Madam President, so who is going to protect people of that nature? What is this system in place to ensure? Because we are talking about there should be no inducements and no arm twisting. But who will be there? Are these things being done and recorded? Is it clear across the board so that judges can see the process clear that there was nothing, there were no offers, there was nothing? This person voluntarily admitted to the crime. There's nothing of that nature, Madam President. And as a result, people find themselves in tremendous difficulty. Another case to mind, Madam President, that I read in my research was one of a lady and her boyfriend, and they went on a trip, and while she remained in the hotel, she didn't know that he had gone to a gas station, committed a crime, and somebody died. 3 years after, they arrested her. They offered her a plea, and she says, well, I don't know anything about this. And they offered her the different things, Madam President, and when she chose not to, they shifted the case not from her boyfriend to her, and they got an informant to say that he saw her in the gas station. See, because she refused. And it seems to be noticeable, Madam President, from those things I've researched, that when you refuse plea bargains, you feel the full brunt of the law. In other words, judges seem to be angry that you are giving them work. Judges seem to be upset that you are not having them to sit there for hours. And as a result of that, now they give you the full thing and they let you know that you should have taken a plea. How are we to protect citizens, Madam President? Madam President, in so many instances, it sounds good. But it has its flaws. Because the innocent also finds itself surrendering to the pressure. Surrendering. And Madam President, it is no strange things because the bargaining table is not necessarily leveled. Madam President, because here is an individual who is arrested, or he's the accused. And he sits there not having the kind of financial backings. And he is offered, as someone has already reiterated, something from the government services to some legal aid, and it was said before. But the prosecutor has everything to his advantage. He has what it takes, leverage. He has support mechanisms. He can call on expert witnesses, whether they are strong or not is not the issue. Madam President, but the poor little guy who can barely live finds himself faced with all of these things, and which can also be fabricated, and is scared to hell that if he doesn't take this plea, crap or smoky pipe. And when situations of that nature happen, Madam President, the average individual will plead guilty. Madam President, another thing that is important is that nowhere in the bill does it refer to the victim's understanding when a plea bargain is being arranged. Nowhere. As a matter of fact, Madam President, in Canada, in Ontario, in Manitoba, Madam President, the victims have a say. Madam President, in Ontario, the victims have the right to submit a victim impact statement at the sentencing stage. The outcome of a particular case may not really be deterred by that statement, but in other cases, in other districts, Madam President, the victims must have access to the information about any pretrial arrangement that relates to a plea that may be entered by the accused on trial. So there must be information given to the victims. If the state decides we are going to enter into a plea, the victim has a right to know. This bill does not suggest that until it reaches the court. But in Canada, they have put that in there because it is important for us to understand that the person that was the recipient of the crime, the one who suffered, continues to suffer while the one who committed the crime is now being offered a deal. Madam President, how come the person who suffered wasn't offered a deal also?
Yeah, the victim.
Why isn't the victim also offered a deal? How come it's always the criminal offered the deal, but the victim is not offered a deal? The victim is not offered a deal to have all his medical bills paid, and the victim is not offered a deal to be treated a certain way and have access to certain treatment. The victim is never offered that. The criminal justice system, plea bargaining, is always to the benefit of the snitch, of the ones who may have committed the crime. Madam President, one writer said that plea bargaining, and my colleague Wayne Sturge made mention of it in passing, and I don't want to make mention of it in passing, that plea bargaining is making a deal with the devil. But the big question, Madam President, is who is the devil in the case? Because there are people may feel that the person who is accused is the devil. And it may not be so. Because in so many instances, Madam President, the devil in real life sometimes has an upper hand, has more back-ends. I always, Madam President, remember cases of temptation in the scripture, and the devil would say, if you bow down, I will give you this. And if you do this, I will give you this. And maybe now, prosecutors have the same power. It was Michael Spratt who said that plea bargain, Madam President, is a deal with the devil. And he went on to talk about the system of plea bargaining. I do not want to pronounce the language wrong, but he said it's a quid pro quo. That's it? Quid pro. I'm not a lawyer. Is that it? Yeah. Amen. So the quid is that the accused gives up his constitutional right to be presumed innocent and waives their right to a trial. In other words, he says the accused relieves the state of the heavy obligation of proving guilt beyond a reasonable doubt. And then he says the core is that the accused receives the benefit of reduced charges, or less jail time, or some measure of certainty about the ultimate sentence. But Madam President, there is something that is so deep. Because the power no longer lies in the hands of the judge. it really lies in the hands of the prosecutor. As a matter of fact, Madam President, in my research, I found out very rarely would a judge go against what arrangements are made in a plea bargain by a prosecutor. Very rare, very rare. So really the person who is determining the sentence is really the prosecutor. The judge is just a stamp.
He's the devil. Prosecutor is the devil.
The prosecutor is the boss.
Sorry.
The prosecutor is a boss. Is the boss in the situation, Madam President. And we have got to be careful as to the kind of power that we are putting in the hands of our prosecutors in plea bargaining. Very important.
Senator Samuel, have a seat. The points that you're making, can I ask you please to move on to some other points, because you've spent quite a bit of your presentation on some of the same points, and yes, you have. And I'm asking you now, as you wrap up, because your time is almost over, to just move on to some other points, please.
In plea bargaining, Madam President, there is a great deal of imbalance. And I must say that. And where there is imbalance, justice cannot be served. In plea bargaining, the accused does not have the strength necessary to counter the prosecution. As a matter of fact, Madam President, people will not admit that there is an imbalance until you sit and you talk with folks who have sat in the situation and they recognize how vulnerable they have become through the process and how dangerous the process can be. Madam President, at the end of the day, it is the person with the upper hand that wins. At the end of the day, it's the people with the support mechanism that wins. And we call that plea bargaining. We call that justice. We say to our citizens that we are offering you something, but really what we are doing is finding a shortcut for a clogged system. Unfortunately, Madam President, unfortunately, I see no bargain. Unfortunately, I see no justice. Unfortunately, I see people being taken advantage of. Unfortunately, Madam President, when we do things of this nature, we find that there are quite a bit of innocent people that have found themselves imprisoned, their life being affected almost permanently, while the persons who may have committed the crime sometimes are so robust in their system and they are so strong in their resolve that they prefer to face the courts because they know through their experiences that it is easier to go to court when a system is skewed, when a system is flawed. But the innocent are unable to think like that when you have lawyers who cannot win a case in court, when you have practitioners who knows nothing about defense, and it's easy for them, Madam President, to accept a plea and tell their clients it's better you take a plea because this is what you're going to face. Madam President, as I wrap up, it is important for us to understand that there is what is called, and I read it, representation by mathematics. And representation by mathematics is that lawyers begin to calculate. Not calculate money, they begin to calculate for their clients what the possibilities are in the sentencing, and they frighten their clients to take a plea. Representation by mathematics. Madam President, it's so important that a lot of representation by mathematics is taking place already and will escalate when this comes into full existence in this country. And I don't know what will happen to the innocent. I know what will happen to those who are guilty. They will take a plea. And as I close, they will get a sentencing discount. Thank you, Madam President.
Senator Edwards.
Madam President, it gives me great pleasure to join in any debate that we have here in the Senate, but it gives me greater pleasure to join in this particular debate because I stand here with a lot of mixed emotions, especially coming into this, because as senators would know, my story has been one that has been very tumultuous. But it has led me to this place where I can contribute to national development and to change in Trinidad and Tobago. And as you all would know, that upon my father's demise, I made a promise to myself and to those around me that one of the things that I would fight for in this country is reformation of the criminal justice system. And that is why it really, for me, is an emotional contribution, because I'm actually getting to do what I set out to do. And I do hope that this can be testimony to the young people looking on and persons across Trinidad and Tobago that the sky is indeed the limit. And once you set your mind to something, you can in fact achieve it. Now, this whole debate, many of the contributions have surrounded whether or not this piece of legislation will deal with the backlog that currently exists in the judicial system as it stands. And for me, the question should not be whether or not that the passage of legislation would immediately reduce crime and the backlog of cases at the judiciary. The question we should be asking is if, in fact, the passage of this legislation and other legislation that are linked or similar would, in fact, be the right thing to do by way of its passage. And the right thing in that justice is provided not only for the primary victim and offender, but also the secondary victim and offender and the wider community. In Trinidad and Tobago, our perception of justice troubles me. We are a very highly litigious society, and we see justice in a fixed way. We see justice as being mainly an eye for an eye and a tooth for a tooth. But for me, Madam President, that is not how I see justice. Trinidad and Tobago is a country in search of true justice, and that does not mean vindication, but rather peace of mind. Justice that one can witness from beginning to end and applaud the transparency in process. And justice that does not simply mean having the best court clothes, but rather means fairness in every sphere of life, especially when it comes to human interaction, in our schools, in our public institutions, and governance structures, and our communities. As one of the features of restorative justice notes, crime should not be seen as an offense being committed against the state, but rather an offense being committed against a victim, be it a primary victim or a secondary victim as well. And with that whole thinking comes the understanding that the actors involved have roles and responsibilities. And therefore, these roles and responsibilities involved in the process of justice being the most important one of that is with regards to the primary offender seeking to make right the wrong that was meted out, and subsequently the role of the victim or victims in being willing to allow a process of repair to take place. Two of the biggest challenges facing any kind of change in this country that I personally see is fear and lack of confidence. Fear that the decision to be taken may be wrong or one that may not produce the desired outcome. And trust in that we do not trust our institutions to do what they have been put in place to do. And that is as a result of our understanding that in Trinidad and Tobago, corruption and collusion is prevalent. I believe it is primarily for this reason that we have not established the Caribbean Court of Justice as yet as our final court of appeal because of that thinking. As well as on the point, I feel as though if we are to adopt this court as our final court of appeal, we will inspire confidence necessary for other Caribbean countries to follow suit. Because it's troubling to imagine that we have the CCJ right here nestled in Trinidad and Tobago, and yet we have not saw that as our final court of appeal. So therefore, if we head down that road, imagine the kind of confidence that other Caribbean countries will have, knowing that Trinidad and Tobago made that bold step. As well as I would also want to briefly make reference to the controversial Section 34, which in my humble view was a good clause to provide justice for persons whose matters were unfairly prolonged because of a judicial sector that has not fully been supported by the kinds of substantive law that has and continues to be long overdue. We must accept responsibility for not being as responsive to the needs of the population. And while accepting that responsibility, ensure that when an opportunity arises, we take full and complete advantage of it. According to Senator Ameen, the main reason persons in the poll that she mentioned were against plea bargaining was because of the lack of public trust in the police, the DPP, and witness protection in Trinidad and Tobago. And that is always something in my time looking on, be it in politics and hearing some of the discussions that persons would have on the ground, they're always saying that we have these problems, and as such, we can't really bring any kind of legislation to the fore because there is always a problem somewhere else in some other sector that would have an effect on this. But my thing is that we need to start somewhere. We need to make the first step in some stead to bring about change in this country. Yes, there would be many facets that we need to fix and to implement, but I do see one step in the right direction as being necessary, regardless of the fact that we need to fix other sectors. And I would also want to encourage that we address the other problems that currently exist. Because as we all know, plea bargaining, as it stands right now, once brought into law, this would not be able to stand on its own. Because we still have the issues with a culture in Trinidad and Tobago, which is one of our biggest problems. A culture of corruption, a culture of collusion, a culture that does not ensure that justice is received in this country. And the question is, how then do we treat with that culture? Because you can have how many pieces of legislation in place, but if the persons who are there to implement and to enforce and to benefit from the legislation, if they have not had a change of heart and a change of mind, then this will amount to nothing. So we need to look at that. But at the same time, I'm not saying that we should not be putting forward legislation that will make an impact on the judicial sector in Trinidad and Tobago. We have a very retributive system of justice in this country, and it needs to move to one that is more restorative and rehabilitative. I believe that the option of plea bargaining allows the process of rehabilitation and restoration to begin in one stead. Because the offender admits to his or her wrongdoings and is willing to accept a sentence which even the prosecutor believes at bare minimum is commensurate to the crime being committed. Because I am very much confident that no prosecutor, especially if the crime is an heinous one, would slap the offender on their wrists and pardon them in that stead. I don't think that we're so mad as a people in Trinidad and Tobago, despite how many other persons may look at that very same situation. So, what I think moving forward in all of this is that we do have to give things a chance in this country. We do have to give certain changes an opportunity to do what they are supposed to do. We have no confidence, and as you were alluding to earlier, Madam President, in terms of in the debate, the police has been mentioned time and time again. If we continue to always point fingers and not address issues head on and do the things that are required to bring about change in this country, then we will never reach anywhere. We have to admit that we have problems across Trinidad and Tobago in many sectors, especially as it relates to the judicial sector in this country. But we have to and we must start somewhere. I do anticipate that other pieces of legislation will come forward to address similar issues in the judiciary. But at no point in time must we, in one stead, see any single piece of legislation as being the fix to every single issue in the judicial sector. This is what one piece of legislation that is going to make an impact. Now, through you, Madam President, I would say to the Attorney General, the Honorable Attorney General, that suggestions have been made from persons, from all senators moving forward. And I trust that these suggestions will be taken into consideration, because as it stands right now, the legislation would need to be strengthened in order to serve its true purpose. And as the Honorable Attorney General always says, that this is a democracy, and as such, the input from all would be welcome. So with that understanding, I do think that at the end of this process, we would have a plea bargaining system that we can all be proud of. But even looking beyond that, Madam President, Trinidad and Tobago, it's high time that we start to be innovative in our thinking and in our ways that we treat governance in this country. When we look at the judicial system, we need to allow the opportunity for innovation to really reign. We need to stop carbon copying a lot of the things that we see on the outside from other countries, and that is really because of our colonial past. We feel as though what is done outside by the metropole might be what we need to adopt in this country, and I think we need to understand more than ever that in Trinidad and Tobago, the talent that we have here, the mindset of our people, despite a lot of the times we see it as being very laissez-faire, we have some very, very talented people in this country who can bring ideas and suggestions to the fore. Why not Trinidad and Tobago be the lead when it comes to justice in the world? We have the potential for it. So I do think that we need to allow the judiciary to experiment in certain ways, to produce systems and practices and procedures that others can be looking to Trinidad and Tobago for in terms of adopting our ways of doing things. So we do have right before us the Criminal Procedure, Plea Discussion and Plea Agreement Bill, an act to establish a system of plea discussions and plea agreements and for matters incidental thereto. With this, I think more than anything, it would reach out to families across this country who have loved ones behind prison bars, whether innocent or guilty. They don't have the opportunity at this very moment to state or plead their case because of our flawed judicial system. I think this provides an opportunity in some stead of comfort to them, knowing that our judicial system is making the kinds of moves necessary to ensure that there is justice for all. Because the fact is, according to Dr. Martin Luther King Jr., injustice anywhere is a threat to justice everywhere. And as such, we need to start thinking how we can ensure that the injustices, while they may be many, are dealt with. And right now, there are persons behind bars in Trinidad and Tobago's jails who have been there for years upon years upon years and have lost faith in the criminal justice system in this country. And we need to do what we can do to restore faith in it. So, as much as we would want to continue to point fingers as citizens to many of the deficiencies that exist, let's also at the same time look at the progress that has been made in Trinidad and Tobago. Mediation. I am a strong advocate for mediation in this country because I do think that it will be the alternative that we require to really begin the process of healing as a nation. We are too adversarial. We are highly litigious as a society. Let's sit down with one another and treat and deal with the issues that are affecting us. We don't need necessarily a judge or a jury or a prosecutor to determine what course of action we should take when a matter arises or conflict arises. Why can't we equip our population, our citizenry, with the skills they require to deal with their own problems? We need to bring back family life. We need to bring back a sense of community in this country. And yes, no plea bargaining and no trial by judge alone and all these things will deal with those issues. That will be treating with things on one end. We need to look at how we are going to deal with crime and criminality from a holistic standpoint in this country. And I think that every single member of the Senate, every single member of Parliament altogether, we have suggestions and we want to ensure that crime and criminality has come to an end in this country. But it will require baby steps and it will require big thinking at times. And we need to provide that kind of space for that to take place. So, Madam President, I would like to make reference to a quote from the Trinidad Express. This would have been published on January 4th, 2014, entitled Plea Bargaining Legislation Can Help. And Senior Counsel Dana Sita-Hall, may she rest in peace, is quoted as saying, "If we continue as we are going now, in 5 years or so, an accused person who is to be tried in the High Court may not obtain a trial for 15 years. Then chances are the jury will acquit with their own ingrained system of justice. This cannot be right. It is time to activate plea bargaining and enable swifter justice." And no words could be truer. We need to put systems and mechanisms in place, and we do have that opportunity now. So I will not go into the technicalities of the bill because that is not my expertise, but I would say that we need different modes of allowing justice to reign in this country, and plea bargaining is an option. It is a tool. It is a mechanism that we can use to ensure and to assist with bringing about justice in this country. So with those few words, I want to encourage at the committee stage that we truly drill down and make the amendments as necessary. But plea bargaining is something that we should allow as an option in our judicial system. I thank you.
Senator Mark.
Thank you very much. Madam President, I want to thank you for allowing me to rise at this time to make my contribution to this very important matter, this important bill before this Honorable House, Senate. Madam President, the bill before this Honorable House, this Honorable Senate, is seeking to repeal the existing law governing plea discussions and plea agreements, which was passed sometime in 1999 under the administration of the then Prime Minister Basdio Pandey, piloted by the then Attorney General Ramesh Lawrence Maraj. It is now approximately 18 years after. And from the reports that we have been able to garner thus far, the legislation has not produced the kind of results that would have been anticipated back then. I read in an article dated June 2014 that both in the years 2011 and 2012, less than 12 accused defendants made use of the provisions contained in the current legislation. We don't have an up-to-date position on how many others since then would have utilized this particular tool or process in order to plea, well, first of all, engage in plea discussion and later plea agreement with a view to having their sentences, first of all, their charges may be reduced or altered, and or their sentences later reduced. But, Madam President, I must say that when we are talking about law in the context of what we are dealing with, we cannot isolate law from the reality of the real society in which we live. And this society, as you know, is based on a system of exploitation of man by man. That is what capitalism is about. It's a system of exploitation. And, Madam President, we also have to focus on a very fundamental matter that occurs in this society that generates a lot of criminality, violence, delinquency, and deviant behavior. And that has to do with the continued maldistribution of income and wealth in this land. As I said to you some time ago, Madam President, the last research data we came upon was that the Gini coefficient revealed that 43%, the Gini coefficient represented some 43%. That is a very highly unequal distribution of income in this country, whilst wealth was concentrated on less than 1% of this society. Less than 1% of this society enjoyed 69% of the total wealth of this nation. Research that was conducted by the United States Research Department revealed that. That was sometime in 2008. So, Madam President, I made these introductory remarks to let you know that there's a basis for the explosion in criminality and crime, where the haves are growing and the have-nots. Well, the haves are becoming richer and the have-nots are becoming poorer. And Madam President, what we are dealing with is another attempt by the administration within this oppressive society to try to bring some degree of reduction, I should say, to what is called a backlog in the criminal justice system. The criminal justice system is very, very overloaded at this time. And as one of my colleagues said earlier on, you have thousands of citizens languishing in prisons across this land for 10, 15 years without a trial. How can that be justice? How can that be fair, Madam President? And we sit idly by and not address this question. But, Madam President, the bill in its present form, I want to submit to you, has a lot of loopholes. and weaknesses, flaws, and deficiencies. And we have circulated over 40 amendments for the consideration of the Attorney General and the government, because we do not want to participate. And I want to make it very clear, we will not be participating in giving support to bad law. We will not be doing that. So we, like my colleague on the independent bench, Senator Nikoli, we would like to be in a system in which there is greater cooperation and agreement and consensus. But as you know, Senator Nikoli, one hand does not clap. Two hands.
One hand does slap.
So it means to say, Madam President, that it is important for us to appreciate that there are provisions or clauses, terms in this bill that are quite obnoxious, oppressive, and should not find their way in modern legislation in a civilized nation. And that is why, Madam President, if we are not careful, this bill, and we have to be careful, Madam President, remember, laws are not made for one political party. Laws are made for a nation. And if you bring laws that you believe can give you a political edge or an advantage, Madam President, it may boomerang on you later on. And that is why we always have to be making good laws, because we want justice, humanity, and fair play, and equality for all of the citizens of TNT. We don't want laws, Madam President, to be skewed in a way that it would benefit one group of people at the expense of another group. And therefore, Madam President, I would argue that in this particular legislation that we are looking at, if we are not careful, it can be used by this administration that is piloting it as a political weapon or instrument targeting its political opponents or enemies, as they would want to classify those that they do not see eye to eye with. And Madam President, I would explain to you the misnomer, the actual weakness in the context of the argument advanced by many that this legislation will help to reduce the backlog in the courts of this country. Because, Madam President, we are seeing that from the evidence I have been able to research thus far, that not many persons have used the current legislation to get out of prison or to have their sentences reduced. My understanding that there's a term called MSI, maximum security indication. Maximum sentence indication, rather. And I understand that is being used more frequently and more regularly than this very legislation that we are dealing with and what is currently on the books, Madam President. So, as I proceed, I will develop the point, Madam President, that whilst the system is very overloaded at this time, we have to ensure that under our Constitution, we seek to uphold the rights of citizens to a fair trial. And that is enshrined in our Constitution, and this is something that we would want to ensure that continues. Madam President. Madam President, there are many challenges that we are faced with in this society, and as I said, the government is seeking through this piece of legislation called plea discussions and plea agreement to try to see what they can do to reduce the backlog. And of course, as I said, as a very responsible opposition, as the alternative government in this republic, we would want to do whatever we can to assist in promoting good legislation and to ensure, Madam President, that legislation is advanced in the interests of the people of this country. Now, Madam President, we know that there are many advantages to be derived from this legislation called plea discussions and plea agreements. But one I've already indicated to you exists, that they hope, or it is hoped, that it would reduce the backlog. Another one, Madam President, in terms of an advantage, is that it can be used as a tool to address complex prosecution matters. And we know for a fact, Madam President, that in the area of complex crimes, that is a tool that can be employed to address that. I think in the United Kingdom, complex and serious fraud matters are in fact used to address difficult cases in the United Kingdom using the very tool that we are debating and discussing in this honorable House. But, Madam President, there must be safeguards. There must be checks and balances to ensure that the system is not abused, to ensure that the system is not misused by anyone, Madam President. And therefore, it is against this background that I want to indicate to you that we have circulated another list of amendments in my name, and that list is to deal with the elimination of the inclusion of the term suspect. We do not know where that term came from. It was not in the original legislation that was circulated to us. It came as a result of changes later on, I suspect, in the other place. But, Madam President, if I may ask you to join me by turning to page 5 of the definition and the interpretation section, Madam President, you will see the concept or this term suspect.
She don't have a copy here.
And it states, Madam President, that a suspect means a person whom a police officer with reasonable cause suspects has committed an offense, but who is not charged. Now, Madam President, this was nowhere in the original legislation. And that is why I'm hoping that when the Attorney General winds up this debate, he will answer the question that Senator Sturge placed on this in the Senate earlier. Has the Attorney General abandoned the whistleblower legislation that he had brought last year? And has he now introduced whistleblower legislation through the back door? And this term that he has now parachuted into the legislation, is that a method, a means by which certain elements in this society would be induced, improperly induced. And that is why we are making an amendment, Madam President, to reintroduce Clause 5 as is in the current legislation, which has been conveniently removed. We understand from the Attorney General and others that at some meeting that was held in 2014 at the Radisson Hotel, there was consensus among certain judges and other lawyers. But I want to tell you something. Judges and lawyers, they have their interests to serve. You see, we in this parliament, and we in the United National Congress, and we in the People's Partnership, we serve in the interests of the majority of citizens in this country. And we are concerned, Madam President, of how that legislation is going to impact on the innocent in our country. And that is the danger of this particular provision. We understand that this provision can be found in Jamaica's legislation. But I think Jamaica's culture might be a little different from ours. I think Senator Nikoli used a term, corruption and... Oh, Senator Edwards, thank you. Thank you. I was trying to remember the surname. Thank you very much. Madam President, you are very alert. Yes. Yes, Senator Edwards. Yes, thank you very much, Madam President. He used this term of collusion and corruption. And Madam President, it is part of the culture in our nation. And we cannot get away from that. We cannot get away from that. And Madam President, without casting any aspersions on anyone, I'm saying all the key players in the system, the dots must be connected. And you can demonstrate that over the years, the system has been polluted and contaminated. And innocent persons have been incarcerated in this country. And innocent persons have been accused in this country. Innocent persons have been humiliated in this country. Innocent persons have been handcuffed and dragged through the streets of Port-of-Spain in this country, Madam President, because of the corruption and the collusion in the prosecutorial system in this country. So we have to be careful. We have to be careful, Madam President, that we do not fall victim. We do not want any part of the Jamaican experience. We like Jamaica. I like Jamaicans. But you see, the suspect in the Jamaican legislation, we say delete that. We want no part of that. And you see, this suspect, Madam President, is also in the Nigerian legislation. One of the most corrupt nations you could think about in the world is Nigeria. We want no part of that. We want no part of that. And that is why we are saying, Madam President, in no uncertain terms to the Honorable Attorney General, please delete and remove that from the legislation. We want no part of it, Madam President. Madam President, may I ask you to follow the story? It's a story, but I want to tell you it's a real story. A real story. A live story. A true story that took place in our republic, Madam President, dealing with, for instance, suspects. Suspects. And to show you, Madam President, how the system, as Senator Edwards described it, is one of corruption and collusion. Madam President, some time ago, a gentleman walked in a police station in this country. He told the police that he had offered hundreds of thousands of dollars to two high-ranking government ministers. And Madam President, he committed that to pen, to writing rather. And that was sufficient. That was sufficient, Madam President, to walk in a police station claiming, Madam President, that he offered money to two high-ranking government ministers at the time. And Madam President, you know what happened? The police took that statement from that individual, and the next thing you knew, Madam President, was that these two high-ranking ministers were arrested. And they were taken before the courts, handcuffed. And they were humiliated. Their reputation was damaged in this country, Madam President. For years and years, Madam President. On what basis, Madam President? Somebody just walk in and give to the police a statement. And that was sufficient to handcuff these individuals and send them in a state of humiliation. One of those individuals are abroad now. The other one is in this parliament.
Yes.
In the Senate. And Madam President, it's a living example of the misuse and abuse of provisions in legislation if you don't get it right. Because any one of us in this parliament can become victims, as those two ministers became, Madam President, if this law is not dealt with properly, and if we do not establish, Madam President, the necessary checks and balances and safeguards to ensure that we do not, Madam President, allow this to develop and to go further. So I just wanted to share with you, Madam President, this issue of the concept of the term called suspect, Madam President. So, Madam President, as I said, these are advantages that I highlighted, and I also recognize, Madam President, that there is a greater degree of flexibility in sentences, allowing and allows the prosecution as well as the defense to construct and to organize more individualized sentences through informal negotiations, Madam President. But, Madam President, on the other hand, there are severe and serious unintended negative consequences that we also have to take on board, that can lead to serious and larger governance issues and human rights issues, Madam President. As my friend Senator Samuel said earlier in his contribution, Madam President, that this tool can be used by the rich, wealthy, and powerful to bargain their way out of trouble. And the innocent and the poor can languish in cells, in prisons, because they don't have the means to deal with this matter. So, Madam President, we are talking about, if you go to clause 4 of this bill, it talks about, you're moving from the position of plea discussion, and Madam President, plea discussion is on page 4, and it tells you is really discussion held between a prosecutor and an accused person or a suspect for the purpose of arriving at a plea agreement, Madam President. And then, so this is what this is telling you, Madam President, that the prosecutor can meet with an accused of, obviously in the legislation, we talk about the attorney being present, and if he cannot have his own attorney, they will provide him with some legal aid assistance so he can get his own attorney. So, Madam President, we have a situation where the prosecutor can meet with this accused person and or suspect in order to have discussions at arriving at a plea agreement, Madam President. And there's where, Madam President, we have to now deal with Section 4, or Clause 4, I should say, of the legislation, which outlines, Madam President, in the context of a plea agreement made between the prosecutor and the accused person or suspect. And it tells you, for instance, how this thing could be worked out in the interest of the accused, Madam President, or even the suspect in this regard. Madam President, I do not believe that the nation of the Republic of TNT knows about this legislation. I know that Senator Ameen talked about a survey or poll that is being run by the Parliament through its communications unit and the Parliament channel, where 80% of the people who were polled said that they're not in favor of this legislation, and 20% said that they were in favor. But I would have liked to hear the views from the Law Association of this country. But I understand the Attorney General has tried to extract from the Law Association its views and comments on this piece of legislation. I think Senator Ramdin talks about the Legal Profession Act and saying that there is an obligation on the part of the Law Association to provide that kind of assistance, not only to the Attorney General, but to the nation as a whole, because this is a very critical piece of legislation. We would have liked to ask the Attorney General to have this legislation as Ramesh Maharaj did. Attorney General, I don't know if you're aware that when Ramesh Lawrence Maharaj was the Attorney General and he was introducing this suite of legislation to deal with the backlog and the criminal justice system, Madam President, these legislation, or this piece of legislation among others, would have been published in full in one of the daily newspapers. No, democracy is a very expensive business. And you have to ensure that you communicate the information to as many people throughout the nation, including Tobago, so that everybody, Madam President, would have a say in the matter, and you give the country an opportunity to comment. Madam President, I'm being disturbed by my friend. So, Madam President, I am saying that if you really want the public's involvement and inclusion in the final product that is going to emerge from this debate, we should have had the privilege of communicating with the population on this matter. And I'm convinced that the government led by the Prime Minister and our attorney, the Honorable Prime Minister, only temporarily, yeah? Because he's going to be removed shortly. So, Madam President, we want to ensure, and I want to appeal to the Attorney General, that please, the Honorable Attorney General exhibited a certain degree of commitment to dialogue and to consensus, Madam President, by having the earlier bill that we passed via the report being referred under 66.1 to a select committee of the Senate. And I would have thought that because of the gravity of this piece of legislation and because of the implications of it, this one is a suitable candidate for a special select committee.
Again?
Yes. So that, for instance, you can bring in interest groups to deal with it. Madam President, we do not want, Madam President, to have a situation where the government has the majority, Madam President, and the government can pass. They can pass the bill without our support. They can do that. And some litigant, somebody who feels that this bill is offensive, can take action at another level. And I think that you all said you all are open to these actions. Okay? You'll have a lot of money to spend in courts. Okay? Good. Yeah, you disturbing me, we're looking for standing orders? You disturbing me, we're looking for... Sorry, madam. All right. Yeah. I should be looking for the standing orders for this lady.
Nah, I can do it next time.
Yeah.
51.
Madam President, let me continue. Madam President, I just want to ask you to, there's an area of the law that we would like the Attorney General to consider in our second round of amendment. I saw in the Jamaican legislation, which I understand the Attorney General looked at and extracted suspect from, as well as the Nigerian legislation. But I saw in the Jamaican legislation, in clause 35 on page 21, where the Jamaican legislation called on the minister who, by order, subject to an affirmative resolution of Parliament, he could amend the schedule. But I noticed that the Honorable Attorney General, in a kind of convenience, he has left out the affirmative that he saw in the Jamaican legislation, and he has put in negative. So I just wanted to remind the Attorney General that there is a provision in the legislation of Jamaica that talks to the issue of an affirmative resolution. And I believe an affirmative is in order given the gravity of the legislation. So we have therefore proposed...
Senator Mark, you have 5 more minutes.
Yes, Madam President. Madam President, we are proposing to the Honorable Attorney General that he should consider amending the legislation to reflect affirmative by deleting negative. And Madam President, if you go to 36 sub 2, again, the Attorney General, I looked at the Jamaican legislation, Madam President, and again, through maybe inadvertence, I don't know if the Attorney General, did not really pay attention to that section of the legislation, or he was more concerned with suspect than anything else. But I want to remind the Attorney General that I have looked at the legislation in Jamaica, and it says, Madam President, that regulations made under subsection 1 of 36, no, let me repeat, 36 subsection 2 states, and I read, regulations made under subsection 1 shall be subject to the negative resolution of Parliament. That is what the Honorable Attorney General has in this legislation. Madam President, we think that it is in the interest of justice and fair play, given the gravity, again, the severity of this piece of legislation and the kind of manipulation, collusion, and corruption that can take place. We are asking that the government replaces the word negative with the word affirmative. That, we believe, would go a long way, Madam President, in providing the nation and providing the people with some degree of comfort as it relates to the ability of the government to simply make regulations and have me and my colleagues come here to try to move a motion to annul. We don't want to annul. We want to debate. So we want you to table the regulations through affirmative resolution, and we come here, Madam President, and we debate those regulations. That is what we are proposing. So, Madam President, I think the hour is a bit late, 8:54. I know that my time in the last Parliament was truncated from 60 to 40 minutes. So, no, I wasn't here. I was in another incarnation. So, Madam President, I know I now have to be guided by the new standing orders, and I know I only have a few seconds to, with your leave, to wind up. I want to, in closing, Madam President, to have this matter referred to a special select committee. Let us put our heads together and bring out good law and not rush this legislation as I anticipate he may wish to do. If he does that, I want to give him the assurance he will not get a single vote on this side in support of the legislation. If he wants our support, we ask him to refer this matter to a special select committee so we can go through this thing thoroughly and comprehensively. I thank you very much, Madam President.
Honorable Attorney General.
Thank you, Madam President. Madam President, it gives me great pleasure to wrap up this debate and to look forward to what is to come in the committee stage. There is so much to say. There's been very, very good contribution by all members that have spoken today. Yes, all. Because we actually touched upon a cross between structural issues of consideration, much wider than just the four corners of this debate, and also on some specific terms and conditions as well. And I thank all honourable senators for lending their minds to this product. I seem to be living in the Senate these days, but it's with great pleasure that I do that, because I genuinely believe that we are of equal mind, all members, in trying to progress the laws of Trinidad and Tobago. I've spoken to the statistics already that stand behind this bill, but I think it important to touch very, very, very in a cursory sort of way upon where we are. You see, Senator Mark said a little while ago that democracy is expensive, and Senator Mark is right. Democracy is indeed very expensive. Our democracy right now sees us running with 11 Court of Appeal judges, 30 High Court judges, 9 judges of the criminal assizes, 48 sitting magistrates, 38 of whom sit in the magistrates' court themselves. We have 14 magistrates' courts, 3 out courts. But here's where our democracy has us. Indictable criminal matters pending at the magistrates' court, the last year published for the judiciary, I'll take that figure, July 31st, 2015, we have 29,090 matters pending, 417 murder matters, 300 attempted murder, 439 kidnapping matters, arms and ammunition 5,788, sexual offenses 3,597, narcotics 5,758, fraud 5,407, robbery 2,726, larceny 2,737. The judiciary at 2016 says in the High Court criminal matters we have 2,337 pending. Port of Spain, of course, accounts for nearly 58% of that. The number of indictments filed on average per year over a 6-year average is 226 per year, but we're only disposing of 111 on average, which is a 49% disposal rate. Of our 226 indictments, which are filed on average per year, that correlates to 2,010 people. Of the 2,010 people, we deal with roughly, in terms of persons, only 6% 95 people alone have their matters disposed of. So the democracy that Senator Mark speaks about is quite true. That democracy results in us as a nation having in our prisons a position of 3,634 people incarcerated, 1,354 of them there for convicted status, 2,280 of them there roughly for remanded status, that is, they are awaiting their trials, 980 plus of them there for murder. Of the 1,300 plus, 80% of these people are there having been given bail already granted but can't be accessed. Some of these trials, outstanding as they are, take us to 17 years outstanding, 20 years outstanding, 15 years outstanding. So we're taking volume against judicial capacity, and many members have focused upon that capacity and are asking what is happening with capacity. We spoke about DPP, we spoke about forensics. From the figures just mentioned clearly, firearms and sexual offenses and narcotics are all matters which can be dealt with forensically. If you had forensics up and running quite right, think of the caseload that can be dealt with because your evidence looks as strong as it does. Because after all, strict evidence is what really drives plea bargaining, which is what this bill is all about. So honorable senators are right. Senator Ramdeen, Senator Sturge, Senator Heath, Senator Edwards, Senator Shrikesoon. We've spoken to the need to improvement in our capacity. And I thought it was an excellent suggestion by Senator Ramdeen that we have specific persons identified to deal with forensics across the jurisdictions of the police, which is where we are. But look at where we stand as a nation. Without going into the merits or coming down one way or the other, the case with perhaps the greatest notoriety for length of time and for the potential to abuse the equality of arms position, because the submission made in the Senate tonight is that wealthy people can stretch the system. We have in our jurisdiction the largest case concerning an allegation of fraud is the Piarco Airport inquiry. Persons are no doubt anxious to have a decision one way or the other. The accused certainly deserve the right of a trial so that their names can be vindicated if that is the case, and certainly the persons who say that there is guilt on the other side or that the system needs to be closed have another point of view. I come down no way unless there is a due process consideration point. Trinidad and Tobago has a classic case of the United States dealing with plea bargaining. In the Associated Press's publication of November 7, 2006, the Miami publication said 2 people pleaded guilty and were convicted Monday to defrauding the government of Trinidad and Tobago in a scheme to rig bids for work on an international airport in the island. And they go through the persons who were convicted. And then they speak to forfeiture of $22 million US, forfeiture of $22 million further in jewelry and artwork, $4 million in money to be repatriated to Trinidad and Tobago, $3.2 million US to Wachovia Bank, $2.9 million to International Bank of Miami, and so they go. But the point is, in another jurisdiction, dealing with a fact matrix in Trinidad and Tobago in 2006, close to $22 million one way, millions of dollars in cash US on both accounts, already dealt with on a plea bargaining position, no doubt because of the strength of evidence put forward. Where do we stand in our jurisdiction? We've heard Senator Mark in particular, in wrap up to the submissions of the honorable senators on the opposition bench, speak to the fact of not knowing where this material comes from. In certain senses, he pointedly spoke to the issue of a suspect, and in particular to the offense balance that ought to be had against an improper inducement for a prosecutor. 2 things in particular. Senator Mark has raised the possibility of a special select committee going to work, as we had done in the bill which we just completed today. Unfortunately, in looking at that position, I'd like to speak to the issue of how a special select committee, I think, on this occasion may not work. It's a good opportunity, but I had a chance, thankfully, to Senator Ramdeen circulating the amendments proposed in the first round. I've not seen the second round yet. I've traversed those amendments proposed already, and I note that a lot of them are close to, if not exactly, the amendments proposed in the other place by the Honourable Leader of the Opposition. I would like to remind, for the record in this House, we not only piloted the bill, had the debate, but we paused specifically to consider the amendments proposed by the opposition, written amendments. We circulated responses to those amendments. That's not usually done. But the amendments as proposed by the Honourable Leader of the Opposition and the member for Princestown in particular were very good for consideration, and there was merit in stopping the debate, and we actually went the step of writing out amendments in response or considerations. We accepted some, we didn't accept others, and we volunteered reasons why. In fact, we stopped that debate again, specifically to consider the Jamaican experience, as Senator Mark has reflected upon it. Again, the Jamaican legislation was something that we were looking at, but the opposition raised it in a very particular context, and we stopped the debate, looked at the Jamaican legislation, and in fact, we again circulated our written view on the Jamaican legislation and proposals that were recommended for us by the opposition to consider to import into our legislation. I've raised these two because I propose to circulate it to all members, so that all members of the Honourable Senate can have a view of what the government's view on the written proposals were, so that we can in fact come to the committee stage forearmed and prepared with positions as to what the policy view is. It's because of policy that I think that we are respectfully in a position where, on a policy position, we're going to have to agree to disagree on a few things. And you see, that's because there are a few cornerstone submissions by the Honourable Opposition, repeated in terms of a sense of doubt or need for clarification by Senator Srikisun in particular, not knowing which way to go, he having professed, the Honourable Senator, of being a layman in the position of considering law. But policy-wise, there are two strong points, as I just pointed to. The position that the bill needs to have a balance for improper inducement by criminalizing the improper inducement is a strong corner policy point. Secondly, we are looking at policy points to include whether we in fact deal with the concept of a suspect, because the proposal is to remove that. I would like to remind honourable senators, in particular on Senator Mark's position of democracy and how bills used to be published in the time of Ramesh Lawrence Maharaj under Basio Pandey. I remind that internet penetration then is not what internet penetration is now, and that there's a certain amount of advantage that we have now with the Parliament channel and the Parliament website, and certainly we have been receiving commentary back from many people. But when we look to what took us to the policy here, I must remind that the workshop report, the National Centre for State Courts and the Attorney General of Trinidad and Tobago, plea agreement, plea bargaining workshop, Radisson Hotel, Port of Spain, Trinidad and Tobago, April 24th to 25th, 2014, report compiled by Ria Reyes and Cassandra Sitahal. This report traverses work that actually saw the participation of panelists from the National Centre for State Courts team, Caribbean Court of Justice, judges of the Trinidad and Tobago High Court, Court of Appeal, and the Assizes in particular on the Criminal Division Bench, magistrates of Trinidad and Tobago, the Criminal Bar Association and Law Association of Trinidad and Tobago, Central Authority, Office of the DPP, Hewarding Law School, Law Reform Commission, Legal Aid and Advisory Authority, Police Prosecutors, Ministry of Justice, Police Complaints Authority, British High Commission of Trinidad and Tobago. I've taken time to repeat those participants because coming out of that workshop was a fulsome discussion in a true democratic way of all of the matters that we have touched on today. as in need of further consideration or further discussion. In particular, discussion under Section 13 of the existing law, we noted that there was a significant point that an accused should be allowed to withdraw from plea agreements. This bill has that. There was a point that the US doesn't contain specific recommendations for specific sentences. There was discussion on that. Again, we have reflected to that. There was discussion on Section 17 of the existing law and the position that judges and magistrates should give reasons for rejection of plea agreements. That is in this bill. There was a discussion that procedure should be included for dealing with plea agreements and that the court should indicate recommended sentences, that the court should reject recommended sentences in plea agreements when it comes to an end. Again, we factored that. There was a position for dealing with the position at preliminary inquiry. That again finds itself here. But when we looked to the DPP's involvement in particular, we saw that the DPP indicated specifically, as did every person in relation to the existing Clause 5, which Section 5 of the Act, Section 5 being the provision which criminalizes improper inducement, every single contributor at this event agreed that the offense associated with improper inducement should be removed. Senator Mark asked whether the government found the position of suspect and the improper inducement removal of criminalization from the Jamaican law. Honorable Senator Mark also referred to the Nigerian law as not a good example for us to follow. But Senator Mark, I'd like to advise or remind you, through the Honorable President, that the policy paper on reform of the Criminal Justice Procedure, Plea Discussion and Plea Agreement Act, Chapter 1307, went into much further detail through the capable work of both Dana Sita-Hall, Senior Counsel, may God rest her soul, and also Mrs. Pamela Elder of Senior Counsel. In dealing with that, we had consultation and specific written recommendations coming back from the judiciary, members of the criminal bar, from QCs out of the United Kingdom. We've had from various stakeholders. And let me stick a pin for a moment. Honorable senators will note as we stand in June that a lot of our work has been paused, largely because the Law Association asked for an opportunity to respond to some of the legislation, and this legislation and the preliminary inquiries and the judge only. And I am to tell you that the government took a decision to pause to allow for that consultation and response to come back. To date, as I stand on the 22nd of June 2017, I have not had the courtesy of a response from the Law Association. I have written on umpteen occasions. I have called 2 successive councils. I don't mean to pour scorn on anyone. I understand that there was a lot of work. We did get very good commentary from the Law Association on the FATCA bill. But the reason that we gave pause was to facilitate further discussion beyond the policy paper, beyond the 2014 positions, but we've not had that response, and so we must press on with our business. But I would like specifically to remind Senator Mark that when we looked to where the concept of a suspect came from, Senator Mark, through you, Madam President, by cabinet note of the Attorney General 2014 number 99, dated the 15th of July 2014, the UNC Cabinet, specifically taking advantage of very good work, approved a policy position for Trinidad and Tobago to consider this law. Specifically, it was recommended that the provisions dealing with prosecution for improper inducement should not be part of the legislation. Victims should be consulted and accorded more rights, but they must not be allowed to express any view on the issue of sentences. Plea agreements should not be more detailed as compared to what currently exists. Should be more detailed, sorry. All plea agreement hearings should be in open court unless the court decides that circumstances necessitate an in-camera hearing. There should be greater judicial oversight at the plea agreement hearing. Provision should be made for the admission of written victim impact statements at the discretion of the court and should be served on the accused. The accused should be given the right to withdraw from a plea agreement if it is rejected by the court. The accused should be given the right to change his plea of guilty on the occurrence of certain specified events. The accused, all statements made at plea agreement hearings or in the course of plea discussions be inadmissible in any other criminal or civil proceedings against the accused. The suspended sentence of imprisonment, intermittent custody, and home detention order should be introduced in the sentencing armory. Every single one of these measures find themselves into this bill. And specifically, therefore, when honorable senators seek to make inquiry as to where matters came from, they in fact came from the very good work that was purchased by the last government through the wide consultation that we had and now finds itself here. But more particularly, under Cabinet Minute 252 of January 29th, 2015, the last government specifically approved a bill, which we have modified after further consultation. But in that bill, I must point out for Senator Mark, through you, Madam President, that the concept of a suspect at law was a feature approved by the last cabinet. Specifically, Section 4, Clause 4 of the bill approved by the last cabinet says, a prosecutor and an accused person, or where the accused person is represented, etc., may at any time before conviction engage in plea discussions. For the avoidance of doubt, a plea discussion may be entered into and a plea agreement concluded before charges are instituted against the accused person. Before a charge is instituted, you are a suspect at law. And the issue of dividing out suspect as we have came about because of the debate in the House of Representatives held in relation to this bill in this session of Parliament, where no less a person than the leader of the opposition made the suggestion that we needed to clean up the bill by separating out a suspect from someone who was charged. And that is how this bill, after a long gestation period, after pausing in the House of Representatives, finds itself with the concept of suspect before us now. So let's forget the fact that a previous government, now opposition, agreed. No problems. This is a different house. We're entitled to change our point of view. I don't mean to be pejorative about it. The fact is that there is merit in including suspects into the arena because, as Senator Heath said a while ago, today in Trinidad and Tobago, there is constant use of informal plea discussion. And that is a feature which is not different from many other jurisdictions. The United Kingdom, Australia, Canada, the United States of America. There are no limitations on suspect or convicted persons, prior to convicted, accused persons who have been already recipients of charges against them entering into these discussions. You see, the opportunity is also amplified by the practice in Trinidad and Tobago where the Director of Public Prosecutions actually gets involved in consulting with the police in relation to this matter prior to charge. Not plea discussion necessarily, but what is an appropriate charge. And there is genuine discussion on that. So we are formalizing into our laws a system which is in practice and unregulated. But Senator Mark also asked the question as to, well, rather, the opposition has advanced the position that we ought to have a balance against improper inducement and that we should maintain what is the feature of Section 5 of the existing law by criminalizing improper inducement. The policy paper, the 2014 forum, conclusively dealt with the issue that every single stakeholder, wide consultation, wide participation, held the heartfelt view that criminalizing this was one of the reasons why it didn't work. And therefore, the proposal to remove it found itself into favor of the government by way of policy prescription. But in the 2015 bill of the United National Congress, specifically, the clause that deals with improper inducement, clause 8, reads as follows. No improper inducement shall be used to encourage an accused person to participate in a plea discussion, full stop. there is no criminal sanction associated with that. Why? Because all of the deep research and policy work which stands on this, which stands behind this, which stands next to it, on either side, any which way you want to look at it, says criminalizing the prospect of improper inducement is something to be frowned upon because it causes the system to grind to a halt. Let's flip it on its head. What is there otherwise to have us deal with an improper inducement? Well, isn't it true that perverting the course of justice is a feature of the common law? Isn't it true that that is something which can be pursued under the criminal law against persons who find themselves in that position, for which improper inducement may well constitute that fact? Isn't it true as well that Section 5 of the existing law, which criminalizes improper inducement, is at a level similar, if not equal to, perverting the course of justice? Isn't it true that in narrowing down the perspective, as we have, by removing police officers from the matrix, by having the Director of Public Prosecution squarely involved, which fits in with the 2014 observations of the current Director of Public Prosecutions, that the use of police officers in this matrix should be frowned upon because of the allegation of improper inducement? Now, as we seek to narrow that down only to the DPP, isn't it true that the Judicial and Legal Services Commission also has disciplinary rights, which can act as a second matrix cover in this? You see, there is adequacy already in the existing law, which, albeit not within the four corners of this particular bill, can be brought in aid to treat with improper inducement. But that is also to be amplified by the fact that this bill proposes that you may enter into a plea discussion in Part 2. You can consider your victim impact statement in Part 3 and its operationality. But when you get to Part 4 of the bill and you're talking about the plea agreement itself, you are taking all of the material to a judicial officer of the High Court. The magistrate must send to the High Court. If it's in the High Court, it goes to the High Court. The judicial officer, with full disclosure, considers the propriety under the administration of justice, with the safeguards for the accused in place, with the improvements that we have now in the forms which make sure that the certification of rights is had. All of that stands as due process, right of fair hearing, safeguards to ensure that the judiciary has the final say. But we don't stop there. It's open to appeal. And the highest court of this land is the Privy Council. There is no limitation on the right of appeal. So we are putting into place, and which is why we circulated for honorable members, a matrix of the process flow of this bill. You see, this bill has been through many years of reflection. This bill has certainly been through, in terms of dedicated work, 2013, 2014, 15, 16, 17. 5 years of consultation. 5 years of input. 5 years of analysis. But honorable members are right. We're not looking at this in a vacuum. We are, and honorable members are aware now, dealing with this thing in a matrix approach, where we are dealing with a number of bills which articulate upon the improvement of the criminal justice system, but we are not hanging our hats, most respectfully, on the pegs of legislation. We're dealing with it specifically when we talk about improvements to the creatures that must carry out the law. 95% of prosecutions are dealt with by the Trinidad and Tobago Police Service in the magistracy. 95% of it. The Trinidad and Tobago Police Service has, in terms of its strength, its sanction strength, of a sanction strength of 7,884 persons, there are 5,400 as at March 2017. When we look to the actual number of attorneys in operation, When we looked at the number of court prosecutors, as at February 24, 2017, there are 53 court prosecutors in the TTPS. There are only 8 lawyers in that pack. When we looked at the number of lawyers in the Trinidad and Tobago Police Service, we have 24 lawyers in the Trinidad and Tobago Police Service. Bearing that in mind, I would like to put onto the record that with the advent of the criminal procedure rules, the government didn't stop there. We executed, and it is now in progress, the decision to conduct a manpower audit in the Trinidad and Tobago Police Service. Why? Because unless you are looking at the efficiency of your Trinidad and Tobago Police Service, with 95% prosecution, with charges that come about only after investigation, unless one knows what the progress of charges looks like, what the time frame between an allegation and a charge looks like, what the number and flow looks like, what the process management looks like, then we are most respectfully spinning top in mud. In a 6-year period, we have spent $15.1 billion on the Trinidad and Tobago Police Service. In a 6-year period, we have spent $27 billion on top of that in dealing with national security and crime. $27 billion plus $15.1 billion. And where are we? Where are we as a country? You see, too many people hide in dark spaces. And by that I mean too many people who are determined to not earn an honest day's pay for effort hide in dark spaces. And they hide because they are not being measured by outputs and deliverables. That is what the manpower involves. But what we did with the advent of the criminal proceedings rules is we went into the Trinidad and Tobago Police Service and we conducted a prosecutorial audit by the creation of prosecutorial centers and case management centers in the TTPS that handle 95% of the prosecutions. We have drafted, in that regard, File Management Manual for Investigators and Prosecutors of Trinidad and Tobago 2016. We have given Case Management in Trinidad and Tobago Service Management Committee report. We have dealt with the bringing up to date of the Compass tracking case system, which has laid in a system of disuse. Senator Ramdeen raised a very important point about the use of cautionary statements and how witnesses gave evidence in this country. I am very pleased to say that the government has acquired video recording suites that are installed and in operation so that you will not have to rely upon witness statements in front of a JP if you're lucky, in compliance with the judge's rules, where you don't know whether the person was beaten, coerced, threatened, or otherwise treated with. But after we call the bluff of the TTPS and other persons, and I'm sorry to put it that way, after we call the bluff as to where the 14 other video recording systems were, because Trinidad and Tobago acquired 14 other video recording suites that were never put into operation. After we bought the other suites, we found the others. And we are insistent that every single interview that is to happen, every statement that is to happen, will be video recorded. Because we must balance the rights of individuals against the right of the state to protect its society, if I can put it that way. I'm, of course, changing the concept a little bit. With that in mind, we haven't stopped there. DNA, I just gave some of the statistics in relation to firearms matters, narcotics matters, sexual offenses in the thousands. Which is why we hurried up and brought in the DNA regulator and appointed the DNA regulator. Which is why we are completing the procurement of the entity to provide the services for the DNA bank and the DNA testing. Because we've already earmarked that is to be finished before September. And we have earmarked that it will take a mere 6 weeks to do the entire prison population in Trinidad and Tobago. When we start marrying hard facts, incontrovertible percentages of probability against the number of matters outstanding, you will understand why we went into the judiciary and we pulled out the 400 cases longest in backlog and said, get them ready for trial. And how do we get them ready for trial? You need a prosecutor, you need a defense attorney, you need evidence, you need courtrooms, you need judges, you need the DPP's office. So we went into action gear by getting the JLSC through advocacy to appoint more JLSC officers. The DPP told us, hold strain. I'm now about to go into new accommodation which the government has sourced in San Fernando and in Port of Spain and in Tobago for the DPP. And the DPP will then tell us, hopefully this month, I'm ready to promote the following and take the rest in. So we've unstuck that system. Last year alone, the Office of the Attorney General provided $88 million in external legal fees to the Office of the DPP. $88 million. So the DPP's office is not under-resourced and is not without an anxious government behind it to provide resources. So we went to the judiciary and we told the judiciary, let us operationalize you. And so we have gone for the financial autonomy of the judiciary, Ministry of Finance, Office of the Attorney General, the judiciary. We're working out the matrix so that the judiciary can spend its own money the way it wants to. And in July of this year, we will be able to open the Children and Family Division courts, having only passed the law last year. That's a first for this country. It is a first for this country. But we didn't stop there. We have already created draft advice, public prosecution service for Trinidad and Tobago. Why? Nobody is managing the prosecutorial management of Trinidad and Tobago. Policemen arrive at court with long lists to be adjourned, which is why the criminal proceedings rules had to come in. Granted, there can be more consultation by the judiciary and the law association with respect to the private practitioners at the criminal bar on the criminal proceedings rules, but you know what? We're no longer talking about them coming into effect. They are in effect. And we've taken the public prosecution service so that we can now manage the cases so that we are ready at court when court starts. Because that's been one of the reasons why trials don't get off the ground. But we've gone a step further. We have specifically built out, which is now about to flow into the Legal Aid and Advice Authority, now that we've reconstituted the authority, a public defender system for Trinidad and Tobago. I went to the United Kingdom, I met with the DPP of the United Kingdom, I met with the head of the Public Defender Service in the United Kingdom. We have arranged for prosecutorial input and assistance. We have arranged for public defender overseeing by the United Kingdom. And we are going to retrofit the Legal Aid Authority into a public defender system on the criminal side so that when your counsel of choice is not available, the state will provide you with an attorney of competence. So trials, backlog now identified, specialist courts which will be opened, prosecutors, defense attorneys, forensic evidence. Do you see what's happening? We haven't been dealing with this thing in a vacuum. We have not been taking this thing in a piecemeal approach. Far from that be the case. We have been looking at the operationalization of laws. Electronic monitoring is right now in progress of final stages for procuring the bracelets, the anklets, the computer systems which have to manage it, the telecommunication systems, the response systems, but we've gone a step further. We went into the prisons of Trinidad and Tobago and we did a case analysis of every single prisoner up to a particular point to look for who had passed maximum sentence. Because what's the point of having someone awaiting a trial for a term of imprisonment which was a maximum amount at 10 years or 15 years and the person was there for 17 years already? What's the point? So common sense was put into the equation. So honorable senators, we have not been slow to think about the remedies. Honorable Minister Stuart Young went to China as I went to Jamaica to deal with the forensics laboratories, because we are looking at a turnkey system on the long run for Trinidad and Tobago, because we need better services in relation to our pathology. We need better services in relation to forensics. We need reliable space and positioning. They have long since outgrown their capacity. But I'm pleased to say that the firearms backlog has gone down. I'm pleased to say that other aspects of it are moving forward. We're now hiving off DNA to deal with paternity for the first time in this country, as we have assented to that law. And therefore, what we're trying to convey to honorable senators is, we've spent a lot of time looking at the systemic problems. Whilst we legislate, we are operationalizing. Whilst we are contemplating pieces to articulate with each other in terms of law, we're building the institutional capacity. We mightn't get it.
You have 5 more minutes.
Thank you, Madam President. We mightn't get it right in the first instance immediately, but nothing clearly has been right. We have a piece of law that we're seeking to repeal that was passed in 1999, and in 2014, 14 people, 12 people alone had dealt with it formally. 12 people in the period 1999 to 2014. And the reason is that the systemic capacity was not improved. The use of evidence on a scientific basis wasn't dealt with. The use of a public defender system wasn't tried out. The use of prosecutorial management wasn't dealt with. Case log analysis, telling Trinidad and Tobago what the real cost of democracy is. Because you know what? The real cost of democracy is the savagery on our streets on a daily basis. None of us here are immune from it. And I certainly get the feeling that every single one of us here, to a senator and to a member of parliament in the House of Representatives, have an abhorrence for crime. And it shows in the contributions of honorable senators. I don't for 1 minute discount the honor behind the statements of intent. Honorable senators, we propose to circulate to honorable members our views on some of the specific clauses recommended by the honorable members of the opposition, certainly those recommended by Senator Choate, as I've got them clear for now. As we get the others filled in, we propose to circulate that out. That's not a usual feature of a parliament. I just wish to remind. I sat in opposition for 5 years here in the Senate, and never once did I have material of that kind circulated, but I will not take that particular approach. It doesn't hurt me to say it in advance. I don't mind if you come. It only helps to improve the product if you've considered it and you come reloaded. I do think that the law is very well thought out. I think that there's no one perfect model to match the positions. I'm confident we can analyze the positions in the Senate. I don't respectfully believe that we'll be able, and I don't mean to preempt consideration of proposals, I don't think that we'll be respectfully able to deviate from the policy of the government as it relates to suspects, dealing with the provisions of putting a sanction against improper inducement, or dealing with some of the approaches that we've dealt with. And in those circumstances, Madam President, I can only ask for careful consideration of honourable members, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto.
Minister of Trade and Industry.
Madam President, I beg to move that the Senate do now adjourn to Tuesday, 27 June at 1:30 in the afternoon, and this will be Private Members' Day. Senator Mark.
Yes, thank you very much. Just get the...
Well, Senator Mark.
Okay.
Before, yeah?
Yes, thank you.
Honourable Senators, before I put the question on the adjournment, leave has been granted for a matter to be raised on the motion for the adjournment of the Senate. Senator Mark. You have 10.
Yeah.
You're not doing it again?
Yes, yes, yes. She just wanted.
I know, we'll deal with that after.
Okay,
at the
right.
later
Thank,
stages.
thank you.
Yeah.
Thank you very much, Madam.
You have 10 minutes.
Yes, right. Yes, thank you very much, Madam President. Madam President, the motion deals with the imposition of a round of new taxes by the government through central bank by rounding off the 1 cent coin. Madam President, banknotes and coins are the most important contact points for central banks with the public. They not only play a key role in the reputation and public perception of the central bank, but is also tied to the public's faith in the strength of the economy and nation. Widespread public acceptance is therefore an important criterion for evaluating any changes to currency and coinage. Madam President, on January the 20th, 2017, the Central Bank of Trinidad and Tobago issued a public notice on its website indicating it would be eliminating the 1 cent coin from circulation. On June the 1st, 2017, the central bank released another notice on its website indicating the following from July the 1st, 2017. 1. The 5, 10, and 25 cents coins with new metallic composition will be issued. 2. No more 1 cent coins will be issued. 3. Cash rounding guidelines will apply. And 4. The central bank will be launching a coin redemption drive in the country. Madam President, there was no prior indication that the central bank was contemplating a sensitive national decision on the future of the 1 cent, and even worse, doing so without the benefit of first having consultations with key stakeholders, consumers, businesses, banks, charities, and even coin collectors. The central bank put forward only one argument for eliminating the 1 cent, an economic case put forward by many other countries that did away with their low denomination coins. Simply put, every 1 cent coin costs more to make than it is worth. The 1 cent now costs 21 cents to make. So every time a 1 cent coin is minted, the central bank loses money. By eliminating the penny, the central bank believes it could save some $9.5 million in minting costs a year. Madam President, a responsible central bank should consider the following issues. What impact would this have on charitable organizations that receive 1 cent coins as donations? What is the potential cost to retailers associated with converting their change-making systems? What is the cost to the central bank of removing pennies from circulation and liquidating them? And what is the potential impact on firms' pricing methods and overall inflation? Madam President, perhaps the central bank did carry out a careful economic analysis of the costs and benefits associated with eliminating the 1 cent coins. Perhaps it presented a strong enough case to convince the Minister of Finance, who by law must approve any changes to our notes and coins, to do away with the penny. What is evident, however, is the central bank failure to communicate to the public that eliminating 1 cent coin will hurt the poor and other low-income groups who already are reeling from higher food and gas prices, higher taxes, a stagnant economy, rising unemployment, and an impending property tax. Cash transaction, Madam President, would now be subject to a rounding tax. If each of the 1.4 million citizens in this country experience a penny of net rounding up per day, this would amount to a rounding tax of $5 million per year. Although the initial inflationary impact of eliminating the 1 cent coin and the rounding tax will probably be small, the effect in dollar terms will accumulate over time to a considerable sum. Conservative estimates put the inflationary effects of the rounding tax on the government and private sectors at least $100 million over the next 10 years. Madam President, the resulting rounding tax is likely to be regressive, mainly affecting lower income groups who also use cash more frequently than individuals with higher incomes. This means, Madam President, that the rounding tax will reinforce the existing regressive nature of the 12.5% value-added tax on food and the 7% online sales tax. The poor would be hit especially hard. Madam President, the central bank cites costs as the driving force behind its move to eliminate the 1 cent coin. But if there were no 1 cent coins, the central bank would have had to produce more 5 cent coins. Nickel also costs more to make than their face value, Madam President. So the central bank will also be losing money on the 5 cents coin when it produces it. Will the central bank soon argue, Madam President, that they'll have to eliminate the 5 cents coin and to round to the nearest 10 cents? In addition, Madam President, will the hidden costs associated with eliminating the 1 cent coins over the period ahead, Madam President, how will that impact on the people? Over the past 50 years, Madam President, the 1 cent remains the most widely circulated coin, accounting for half of the total volume of all coins in circulation. On average, Madam President, some 45 million 1 cent pieces are minted each year in this country. What are the plans of the central bank to deal with the massive outstanding stock of 1 cent coins that will come back? Madam President, regardless of the strength of its economic argument, the central bank should not underestimate the emotional attachment Trinidadians have to the 1 cent. What is the training mechanism in place put by the central bank for cashiers at supermarket outlets, at gas stations, and other retail outlets, Madam President? Madam President, this is a cash-based society. Madam President, the central bank has not produced any guidelines formally to the public of Trinidad and Tobago. They have not provided any formal training as far as I'm aware and public education insofar as this decision to eliminate the circulation of 1 cent coins from the 1st of July 2017, Madam President. Madam President, there are 8 more days to go before the 1st of July and before the elimination of the 1 cent coin. And the central bank has failed miserably to communicate to the public of this country as to what is involved in this exercise. Madam President, like TTT, like BWI, 1 cent coin is very closely associated with the population of this country. And therefore, I would like to ask the Honorable Minister of Finance what mechanism have been put in place to deal with this matter. Thank you very much, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, thank you very much. Madam President, I want to have as much respect for my colleague, Senator Mark. In 1979, when he graduated from the University of the West Indies with a degree in economics and politics, I was still in primary school. And tonight, I really expected to hear from him more of the economics and less of the politics. And I must say I was disappointed, because just before coming into the Senate, I viewed a video that is posted on the website of the former Governor of the Central Bank, Jawala Rambaran. And I have no issue with Mr. Rambaran. I myself looked at the 15-minute video. And in looking at that, I saved myself listening to much of what Senator Mark has said. The little data that has been presented is on the video, and the 4 points in support of the motion comes from that video, except that I don't know who produced the video, except to say that the only place I've seen it is on that particular website, which I don't frequent very often. I would make a few points, Madam President, in response to this motion. The first is to say that there are 5 steps in dealing with this matter. And the first and important point I want to make is that this is not a creation of the People's National Government, People's National Movement government. In fact, Madam President, when you look at the 1 cent, the hummingbird is shown on one side feeding on a balize. And we would have been happy to preserve the 1 cent piece if only for that. But the fact is that long before 2015, the central bank had been examining the issue of the 1 cent piece, 1, and 2, the composition of all the coins that are in circulation, Madam President.
Just 1 minute, please, Senator Ameen. You can have your crosstalk, but just not as loudly when it becomes the talk, okay? Minister, continue, please.
Thank you, Madam President. I was quite prepared to continue on. So, Madam President, it's the consideration not only of the cessation of the circulation of the 1 cent, but also the change in the composition of all the coins was a decision under consideration by the central bank long before October 2014. The second point is that the board of the central bank in January 2016 considered and agreed to recommend to the Minister of Finance 2 things: a change in the existing metallic composition of the Trinidad and Tobago coins to a more cost-effective composition using modern technology of plating, and 2, the elimination of the issuance and later the monetization of the 1 cent piece. So the 2 elements, or the 3 elements, are the change in the composition. Secondly, the elimination of the issuance. In other words, the bank will cease issuing new coins. And third, ultimately, the removal of the 1 cent piece as a form of legitimate or legal currency in Trinidad and Tobago. And the third step, Madam President, is a legal notice published by the Central Bank in keeping with Section 26 of the Central Bank Act, Chapter 7902. And that is legal notice number referred to as the Central Bank Coin Standard Weight and Composition Regulations 2017. And that dealt with the issue of the composition of the coins that are currently in circulation. The fourth step, Madam President, is that effective July 1st, 2017, the Central Bank will take steps to introduce in its new composition the 5 cents, 10 cents, and 25 cents coins. And at the same time, deal with the elimination of the 1 cent coin. And it will deal with that in 2 stages. The first, a period from July 1st, 2017, when it would encourage the public to voluntarily stop the use of the 1 cent through rounding up, and the part that Senator Mark omitted, rounding down. And what that means, Madam President, and I just want to answer Senator Mark on the issue of the lack of work done by the Central Bank to educate the public, and I disagree with that, Madam President. The very same website Senator Mark went on to, the Central Bank website, you'd see a lot of information available to the public in relation to this process. And in fact, Madam President, I'd read for you the schedule of public education sessions being conducted by the Central Bank. June 21st at the Central Bank, June 22nd today at the Orsonville Mall in Tunapuna. It's gone already, Senator Mark. You wouldn't be able to make it today. June 23rd at the Victor E. Bruce Complex in Scarborough. June 28th at Gaston Court in Chaguanas. And June 29th at the Mayaro Resource Center in Mayaro. And Senator Mark, I'll be happy to have you there on June 29th with me.
The MP will invite me.
The MP and I will invite you. Very well.
I'm going to try to take over the man now.
Once you come and educate yourself.
I will come, but
because on that day, the Central Bank will tell you not only about rounding up, but rounding down. And I would say in relation to the motion, Madam President, so those are the steps to be taken. And after this voluntary period, there will be a final step, which is the demonetization of the 1 cent, the removal of the 1 cent as legal currency, after which it will cease having been, you would not be able to use it. So, Madam President, in relation to the motion that is before us, I would say that the work of the Central Bank has gone on for a period of time. The Central Bank, after January 2016, provided advice to the Minister of Finance. Cabinet approved the recommendations of the Central Bank. The Central Bank has gone into activity, which is to change the composition of the coins which would remain in circulation, the 5, 10, and 25 cents coins. We'll go into a period, a voluntary period, where we'll have rounding up and rounding down, and then we would go into a period of demonetization. Most importantly, on the rounding up and rounding down, Madam President, there will be instances in which the rounding up would lead to a few cents more, and the rounding down would lead to a few cents less. And I would say that absolutely nowhere in Senator Mark's motion is produced evidence to demonstrate that the rounding up, the rounding down will lead to any additional burden on any consumer anywhere. I accept that everywhere the issue of eliminating small coins has arisen. There's been this discussion on rounding up and rounding down, and the expression of it being a tax. I accept that in some economies, the effect, the inflationary effect, and the taxation effect, if you could call it that, outweighs the value of the elimination of the coins, and in some economies, the elimination is much higher in terms of impact than the so-called rounding tax. And I've seen and heard nothing to the effect. I think that the central bank is on the right road.
Minister,
it will lead to...
Your time is up.
Thank you very much, Madam President.
Honorable Senators, I will now invite Senators to bring greetings for the Eid al-Fitr celebrations to be held on Monday, June the 26th, 2017. Minister of Rural Development and Local Government.
Thank you very much, Madam President. On behalf of members on this side and on my own behalf, I am delighted to share in this honorable House, through you, Madam President, my heartfelt Eid al-Fitr greetings to the Islamic community both at home and abroad, and to all citizens of our beloved and diverse nation. Throughout the month of Ramadan, Muslims across the world have once again deepened their practice of their faith through fasting and reflection on the values of peace, harmony, and cooperation that are the heart of Islam. Preceding this month of Ramadan, which is the 9th month of the Islamic year, that's the Islamic calendar year, we observe the month of Shaban, in which we prepare for the whole month, which is fast approaching. We approach Ramadan with great happiness, as during this month, the blessings of Almighty Allah are magnified 70-fold, making the end of the month of Ramadan and the beginning of the month of Shawwal. We observe the Eid al-Fitr. We are delighted to celebrate Eid al-Fitr with all citizens. This is a time of personal, family, and social renewal as we pray and gather together. The spirit of peace, brotherhood, and harmony at the heart of the observance of Ramadan and the breaking of the month of fast on Eid al-Fitr is something that everyone, regardless of creed or religion, can take away from the observance and apply to their daily lives. Fasting serves many purposes. During the abstinence from permissible, that is, the fasting from eating, drinking, and all forms of enticement or temptation, Muslims are reminded of the suffering of the less fortunate, so that we remember to have compassion to our fellow men. Fasting is also an opportunity to practice self-control and to cleanse the body, mind, and spirit. As Ramadan comes to an end, people pay zakat, which is charity and is an annual earnings of 2.5%. which is among the fundamental pillars of Islam. Along with observing fasts, helping the less fortunate is of great importance, not just at the time of the year, but as a part of a devout and complete Islamic way of life. Especially now, given our recent challenges, it is important that we share the profits of our hard work with our brothers and sisters across Trinidad and Tobago. We have a responsibility to give to those who are less fortunate and will truly benefit. We must be our brothers' keepers. And Madam President, I want to take this opportunity that our brothers and sisters who have just went through the flood, the storm, that we give charity. I want to encourage the Muslim community to give charity to those less fortunate who have been affected. And I have seen firsthand the children suffering, and they need clothes, they need foodstuff, they need material, they need housing material, roof material. So whatever they can give back to these less fortunate people, all over in the 14 corporations, especially the southern area, from Toko, Manzalona, Mayaro, Princestown, Debe, Pinal Debe, Siparia, that whole area. And Madam President, I have intention of visiting all these corporations shortly. It is during the month of Ramadan that Allah revealed the Holy Quran to the Holy Prophet Muhammad, upon whom be peace. One night, a voice called to him from the sky. It was an angel, Gabriel, who told Muhammad, peace be upon him, that he had been chosen to receive the word of Almighty Allah. In the 23 years that followed, Muhammad, peace be upon him, found himself with the most precious gift and began reciting and transcribing the Holy Quran. In giving the word of Almighty Allah to his fellow men, the Prophet Muhammad, upon whom be peace, delivered to us the most profound mercy from the Almighty. At many mosques during Ramadan, a portion of the Quran is recited each night, and the prayer is known as Al-Rawi. In this way, by the end of the month, every scripture of the Holy Book is recited. Eid is an Arabic word which means recurring happiness or festivity. Ul is simply the article D. Fitr means breaking of the fast. Eid al-Fitr, therefore, can be translated to mean the festival of breaking fast. In Trinidad and Tobago, Eid al-Fitr was first declared a holiday in 1967. I was just around 8 years old. Not yet old enough to participate in the month-long fast, but not without a profound knowledge of the significance of Ramadan. My father would take my brothers and me to the mosque every evening so that we could feel a part of the brotherhood that builds during the holy month. As we held hands and walked to recite the evening prayers, I certainly felt the sense of togetherness building within the Jamaats. When Dr. Eric Williams announced to the Islamic community one of the celebrations recognized nationally, he gave to the Muslims across Trinidad and Tobago a brand new bond of togetherness was formed at the national level. This reinforced the diversity of our people, and it recognized the contributions of the Islamic community to the political, social, and economic fabric of Trinidad and Tobago. Islam was widespread across the country long before it was given national recognition by the administration held by the People's National Movement under the leadership of Dr. Eric Williams, and an administration in which an Islamic brother, the late Kamaluddin Muhammad, may his soul rest in peace, was very prominent. We must be thankful for the visionary, progressive, and inclusive leadership that has always characterized those at the helm of our party. So on behalf of the government of Trinidad and Tobago, I extend blessed Eid al-Fitr to our beloved nation with firm conviction that the contributions of our Islamic brothers and sisters is an integral part of what makes us all Trinidadian and Tobagonians. I want to wish all good health, long life. May Almighty Allah grant us good in this world and good in the hereafter, and may us live to see many more Eid Mubarak. I thank you, Madam President.
Senator Ameen.
Assalamu alaikum. May the peace of God be with you. The Muslim holiday of Eid al-Fitr, or Eid, celebrates the end of Ramadan, the holy month of fasting. The observance traditionally begins with the sighting of the new moon of the 10th month of the Islamic lunar calendar. This year, Eid falls on Monday, June 26th. On behalf of the Opposition United National Congress and this Senate, I extend warm greetings to our Muslim brothers and sisters of our beautiful Republic of Trinidad and Tobago on this most auspicious occasion of Eid al-Fitr. May Allah find your fast worthy of reward, and may He shower you, your families, and our nation with blessings of love, harmony, wisdom, and prosperity. Madam President, in Islam there are 5 pillars: Shahada, faith; Salat, prayer; Zakat, which is charity; Sawm, which is fasting; and Hajj, or pilgrimage. Over the past holy month of Ramadan, the Muslim community would have demonstrated great discipline and sacrifice in adhering to these pillars. Ramadan marks the anniversary of the Quran being revealed to the Prophet Muhammad, peace be upon him. It is said that part of Ramadan's purpose is to feel that hunger that the poor person would face every day, so that we could appreciate the sorrow of the sick and to review our own lives to get closer to Allah. It is a call for introspection, moving beyond the shallowness of daily routines to seek inner truth and peace. Whether we are Muslims or not, there is a valuable lesson in Ramadan and Eid al-Fitr for all of us, if we allow ourselves the spiritual and emotional space to put aside our differences. It is my hope that the example of sacrifice, devotion, attention to family values, belief, and kindness within the Muslim community demonstrated during this holy month of fasting and the celebration of Eid itself makes a positive impact on all our citizens. The contribution of the Muslim community to national development has been and continues to be invaluable to the growth of our country in education, in business, culture, social work, media, and yes, politics. I commend you, the Muslim community, on the selfless service you perform for all citizens of our beloved nation. Today, as our national community shares the radiant joy of Eid celebration, it is my wish and prayer that the blessings of Allah light your way and lead you to happiness and peace. There is perhaps no better time than during this, one of our national days of observance, to express as our nation our thanks to God for the blessing of our unique diversity and harmony that we have been bestowed as a nation. The words of our national anthem indicate a noble objective. Here, every creed and race find an equal place. We must, as citizens of this multi-religious nation, always keep our hearts open to understanding that though different, we all stand equally in the sight of God. Religion must seek to unite rather than divide peoples and nations. The celebration of Eid al-Fitr comes all the more meaningful as its message of unity, brotherhood, peace, and forgiveness becomes a reality to both Muslims and non-Muslims alike. At this time, there is a phenomenon of the corruption of the Islamic belief from a message of peace to one of terrorism and violence. We are not immune to this in Trinidad and Tobago, and so I urge Muslim citizens to share information on the true beauty of Islam to non-Muslims, and for non-Muslim citizens to educate themselves on what Islam truly is, as I do believe education is the lamp to erase the darkness of ignorance. Thomas Jefferson said bigotry is the disease of ignorance, of morbid minds, enthusiasm of the free and buoyant. Education and free discussion are the antidotes of both. At this time of celebration, let us remember that it is by working together, holding hands in the spirit of unity, and building on the firm foundations laid by our ancestors, that we will make Trinidad and Tobago a better place, where there is peace and prosperity for all. May the blessings of Allah fill your life with happiness and open all doors of success, now and always. Eid Mubarak.
Senator Edwards.
Assalamu alaikum. Eid al-Fitr is an important religious holiday celebrated by Muslims worldwide that marks the end of Ramadan, the Islamic holy month of fasting. There are more than 100,000 Muslims making up the population of Trinidad and Tobago. Eid al-Fitr is an occasion for prayers when the Muslims gather in large congregations, standing shoulder to shoulder to demonstrate the equality and equity which is the inherent feature of Islamic society all over the world. But the greatest significance of this day of rejoicing lies in the fact that on this day, every Muslim is enjoined to give the needy food at the rate of the prescribed weight per every member of his household, including servants sheltered under his roof the preceding evening. Eid al-Fitr then serves a threefold purpose. It places upon every Muslim the obligation to remember Allah and offer Him thanks. It affords him an opportunity of spiritual stock-taking in that he can now ponder over the strength of his will or the weakness of his character, as the case may be, which manifested itself during the preceding month of Ramadan. It also is the day for the haves to share a portion of what they have with the have-nots. The first Muslims to arrive in this country arrived from Africa, brought as slaves by the colonists. From the 1840s, Muslims came from South Asia as part of the Indian indenture system to work on sugarcane and cocoa plantations. While Muslims today are mostly of South Asian descent, there are converts from all races. Therefore, on behalf of members of the independent bench, we wish the Muslim community a safe, holy, and reflective Eid al-Fitr. Let this be a time that we do not see our Muslim brothers and sisters as threats to our safety and peace of mind, but rather as allies, as they have been and continue to be in contributing to the development of Trinidad and Tobago. Eid Mubarak. Assalamu alaikum.
Honorable Senators, it is my privilege to join with those who have spoken before me in bringing greetings to members of the Muslim faith on the occasion of Eid al-Fitr. As we have heard, this Eid marks the end of Ramadan, a holy period of fasting and of prayer. Ramadan is a time of self-discipline and self-restraint, and the fasting is not only of the body, but also of the mind, with both serving to guard the person against wrongdoing and evil. Eid, although it may come after Ramadan, is not the end of holiness, but rather serves as an opportunity for renewed commitment to ongoing holiness, and is a time of stock-taking and self-analysis. It also is a time of charity, marked by the giving of alms to the less fortunate, as an example of faith in action. In Trinidad and Tobago, the celebration of Eid as a national holiday underscores this country's diversity and our respect for one another's religion, and deepens the spirit of harmony and peace in Trinidad and Tobago. It is therefore with great pleasure that I join in wishing all Muslims and all of Trinidad and Tobago Eid Mubarak. Honorable Senators, Senator Mark, I think you wanted to say what you will be dealing with, yes, before I put the question.
Thank you very much, Madam President. May I advise the Honorable Leader of the acting leader, your good self, Madam President, and my colleague on the independent benches, that we shall be addressing motion number 2 in the name of Senator Wayne Sturge.
Honorable Senators, the question is that this Senate do now adjourn to Tuesday, the 27th of June, 2017 at 1:30 p.m. All in favor say aye. Aye. Any against? The ayes have it. This Senate now stands adjourned to Tuesday, the 27th of June, 2017 at 1:30 p.m.